Morning, Madam.
Good morning.
Good morning, Deputy Registrar. This is Alia here. I'd like to just begin by reading out a short statement, if that's okay, and I will ask you and the parties to confirm if it's correct.
Of course.
This case management conference is in the matter CFI-021-2020 before the Deputy Registrar Nour Hineidi and is being held by way of teleconference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on the Deputy Registrar's instructions. The claimants are represented by Evershed Sutherland. Lead counsel is David Craig. The defendants are represented by KBH Qanun. Lead counsel is Bushra Ahmed.
That is correct.
Yes, that's correct.
Thank you very much. Mr. Craig, let's start with you, please.
Well, Madam, we're grateful to the court for listing a further hearing to deal with the question of whether the trial should address the issue of quantum as well as liability and injunctive relief. Madam, we hope that you received a copy of our note for this hearing and also a note from Ms. Ahmed.
I have, thank you very much.
And Madam, you'd have seen that we set out at paragraph 6 of our note that it's the invariable practice of the...
Yes. Hello. Mr. Craig?
Madam, it's Ms. Rogers. We seem to have lost Mr. Craig. Let me just see if I can reach him.
Thank you very much. Thank you.
Madam, I think I seem to have dropped off the line.
Yes, you had Mr. Craig.
I'm not sure at what point I did. I'm sorry.
No, that's okay. It was quite early on, so perhaps we can start from the beginning again. Thank you. Sorry to trouble you with that.
No, not at all. I was first of all just confirming. I hope that you had received our note. I think you said that you had, and also a note from Ms. Ahmed.
Correct. Yes, I have.
And I went on to say that we have set out at paragraph 6 of our note that it's the invariable practice of the English courts in cases such as these to expedite issues of liability and injunctive relief only, and to leave the question of quantum over to a further hearing if necessary. But I'll come back to that if I may in the context of the defendant's submissions, because I thought it might be most helpful just to deal with practical considerations first. And in that context, Madam, it's doubtless clear from the correspondence that we have been proceeding for months now on the basis that it had been agreed that a trial would be limited to issues of liability and injunctive relief. Now, it may be that the defendants have been proceeding on a different basis and that there has been genuine confusion about the position. And we don't ask you to resolve that now, but can I at least show you our understanding of what sort of trial we have been talking about since February? And Madam, do you have the bundle for the hearing today?
I do have the bundle. I'm just trying to navigate it on the CMS. I think what would be helpful for future hearings in the event, hopefully no further CMCs are needed, but for future hearings, whether they're substantive or procedural, it would be helpful to upload the bundle onto the e-bundling platform. It just makes it a little bit easier to navigate. But just bear with me, please, while I try and find the bundle. Was the bundle filed on the 8th of June?
I believe it was, madam. I believe it was filed yesterday morning together with our notes, I think.
Excellent. I've got the bundle with me now.
Thank you.
Thank you.
Well, madam, if I can ask you just first of all to turn, please, to page 60.
It's just loading, thank you.
Madam, will you let me know when you've got that, please?
I will do.
Thank you.
Thank you, Mr. Craig.
So just to orientate you, this is our draft order for the interim injunction application that we issued on the 25th of February, so right at the start of these proceedings. And if you look, please, at page 63, you'll see we proposed directions for a trial on the assumption that we were granted interim relief. And you'll see at paragraph 8, there would be a trial limited to issues of liability and injunctive relief only. The liability trial with directions are set out below. And then just ask you to note at paragraph 15, no expert evidence being necessary for the liability trial, no party has permission to rely upon expert evidence. And then, madam, moving forward in the chronology to page 156, please.
Yes.
Madam, that is a letter dated the 23rd of March from Evershed Sutherland to KBH, enclosing a draft order for agreement. And madam, you don't have the draft order in the bundle, but I can tell you, and I'm sure there'll be no dispute about it, that also contained the same provisions, effectively, that there'd be an expedited trial limited to issues of liability and injunctive relief only. And the response from KBH is at page 158. And madam, you'll see at 1.2, at trial, subject to para 1 above, and court's agreement, we're happy to agree a trial window of 4 days commencing on Sunday, the 10th of May. Now, it may be, as I say, that KBH were talking about a trial on all issues, but we had made it clear in both of our draft orders for directions that we were talking about a trial on liability and injunctive relief, and certainly they never said, well, we're talking about a different sort of trial. And madam, then next, just moving forward another month or so to page 165.
Yes, thank you.
Madam, this was a letter we wrote to the court on the 17th of April, and just halfway down the page, Roman numeral 1, we set out, certainly this was our understanding, that it had been common ground between the parties throughout the proceedings, subject to the court, there should have been expedited trial of all issues of liability and injunctive relief. And at page 175, madam, you'll see a draft directions order, just to orientate you. This is a draft directions order from KBH. This is on the 21st of April. And you'll see at page 176, at paragraph 17, that KBH there referred to the trial of this matter be listed for 5 days. But we had understood that to be a trial on liability and injunctive relief. And just by way of example, if you look in those draft directions, you will see that there is no direction for expert evidence, which would of course be necessary were the trial to include issues of quantum. Madam, just so you've got the chronology, page 178. I take you to this because Ms. Ahmed, I think, relies upon it in her submissions. We wrote to say that the directions were agreed with the exception of the trial date, and Madam, you'll recall this is the issue that came before you when we were last before the court.
Yes.
But that was clearly on the understanding that this was to deal with issues of liability and injunctive relief, because we attached to that an order or a draft order at page 180, which again made clear that there was to be an expedited trial on issues of liability and injunctive relief only. And then, Madam, at page 204,
thank you.
These are our draft directions on the 12th of May. And Madam, just for the context of that, if you go back, please, to page 197 to 198.
Yeah.
Halfway down the page, you'll see that this is an email, sorry, of the 12th of May, and the third paragraph of that email, we made clear that we were reverting to our draft template to ensure the directions reflect the fact that this is a trial of liability, in respect of liability only. And then over the page at 198, the second paragraph down, we had said to KBH that we were content that the defendant should have an extra week to submit their further information. You'll recall that you made an order that they should do so by the 11th of May, but that was on the basis that the defendants agreed to our draft order. And at page 207, towards the foot of the page, you'll see that Ms. Ahmed wrote to the court to inform the court of the parties' agreement to vary your order.
Yes. Mr. Craig, are you there?
Madam, I apologise. I think we've lost him again. Let me just try and reach him.
Thanks, Ms. Rogers.
Madam, I'm sorry, I keep dropping off the call, off the hearing. I'm not sure why.
No problem.
I'm in a different location.
No
I'm in a different location today. I'm in fact in chambers, so the internet connection should be
stronger.
Extremely good, but I can only apologise.
No problem at all. I think
so, Madam, I think I take. Yeah. I'm just taking you to the fact Ms. Ahmed wrote to the court to say that it had been agreed to vary the direction. And then at page 217,
yeah.
Ms. KBH wrote to the claimant solicitors, and at 218, paragraph 9, this is a letter of the 17th of May, you'll see that the defendants there said that it has always been their intention that any trial would deal with both issues on liability and quantum. And Madam, we don't accept that. Indeed, we understood the defendants to be changing their position, which is what prompted our letter to the court on the 19th of May, which, Madam, you may well have seen, which is at page 231. where we made clear that the expedited trial should be on issues of liability and injunctive relief only. And Madam, as I say, it may be that there was just a genuine misunderstanding between the parties, and it may be that you simply don't need to resolve who's right and who's wrong about that. The question really is, how do we move forward from here? And as to that, it's simply not practical in our submission to drop quantum into the mix now, and in any event, it would be contrary to the overriding objective. And just to remind you, we are 12.5 weeks away from trial today, assuming that we start a trial in early September. And Madam, I wonder if I could ask you just to pick up at paragraph 9 of our note.
Yes, thank you.
So, Madam, there have been no pleadings as to quantum. We haven't served a schedule of loss, nor is there any counter schedule. So we have no idea what the defendant's arguments would be on quantum. And the defendants say in their written submissions, well, it's good practice to serve a schedule of loss and a counter schedule, but in fact, there's no obligation to serve either under the DIFC court rules. But, Madam, with respect, we say in a case such as this, it's unimaginable that the court would not order preparation of a schedule of loss and a counter schedule. Secondly, we have undertaken no disclosure searches in relation to quantum, and that would be a substantial exercise. Disclosure and inspection is due on the parties' agreed timetable on the 11th of June, in other words, in 2 days' time. And there is no time to undertake a further disclosure exercise now. The defendant's answer to that is to say, well, push it back by a week to the 18th of June, but a week is not sufficient time for what will be a substantial exercise. And that would mean delaying all disclosure in what is already a compressed time frame, given where we are and where trial is, which would be wholly unsatisfactory, or it would mean having disclosure on liability now and then disclosure on quantum at some later date. But that is a huge distraction for my clients and its legal team in preparing for this trial. Thirdly, so far as we are aware, the defendants haven't undertaken quantum disclosure, and we anticipate that would be a substantial exercise too, for the reasons that we set out at paragraph 9.3 of our note. But more than that, we would want the assistance of an expert as to the disclosure that we would want to see from the defendants. But unsurprisingly, we have not even instructed an expert. Fourth, there has been no correspondence on the scope of disclosure searches on quantum, unlike the position on liability. Fifth, there would inevitably have to be a confidentiality protocol to govern the disclosure of sensitive financial documents. We, unsurprisingly, will not want the defendants to have carte blanche in seeing details of our clients and the revenues generated from those clients, and we assume that GMG would want to take the same approach. So that will add yet further complexity and realistically another court hearing, given the inability of the parties in this case to agree matters. Sixth, we have been progressing our witness evidence on liability and injunctive relief. And Madam, I'd remind you in that regard that we only received the defendant's further information on the 18th of May, so just a few weeks ago, when we were served with 36 pages of additional information about his case. That's Mr. Olayanju's case. So we have a lot to be getting on with. But we haven't even considered which further witnesses we would want to call on issues of quantum, nor whether they would be available to prepare witness statements in accordance with the current proposed timetable, nor whether they would be available for a trial in September. And obviously, they won't be available for a trial in September, or indeed, frankly, to deal with any of those matters in between. That is going to derail the trial timetable. Madam, seventh, expert evidence will follow witness evidence, but witness evidence is not due to be completed until the 24th of August on the parties' timetable, and there is plainly insufficient time for expert reports to be prepared and served thereafter if a trial is going to take place in September. And Madam, I should say the defendants don't now dissent from the fact that expert evidence would be necessary. they have included directions for expert evidence in the draft order that they attached to their case management information sheet that we received yesterday. And that is the first time that they have sought to include directions in relation to expert evidence. The defendant's suggestion seems to be that expert evidence should come before factual evidence. But with respect, that is nonsensical, and there is no proper basis for expert evidence to precede factual evidence. And indeed, it's difficult to think of any circumstances where that would be appropriate. And in that context, can I just deal with one small point in the claimant skeleton at paragraph 13 of their skeleton, if you've got that to hand?
I'm just going to pull that up quickly, please.
Yes, of course.
Sorry, Mr. Craig, which paragraph was it that you're referring to?
Sorry, it's paragraph 12. I'm sorry, I said paragraph 13. I meant paragraph 12. It's page 5.
Thank you. Yes, I've got that. Thank you.
Where it is said that at the time that we filed our particulars of claim, our position was that our damages claim could be proved following document production and or following provision of expert accountancy evidence. And they say, in other words, it was understood that we may not even rely on expert evidence to prove the loss claims. Well, madam, that is both bizarre and wrong. Can I take you to our pleaded case at page 14 of the bundle, paragraph 40?
Thank you.
What we in fact say there, it's the second sentence, third line down of paragraph 40. We say full particulars of such loss and damage will be provided as and when the same is known to TP-ICAP, including without limitation following document production and or the provision of expert accountancy evidence as to quantum, but TP-ICAP will claim amongst other things, and then various heads of loss are set out. So that was simply about particularizing our claim on loss, not about how we would go about proving our case on loss. And there was no implication that we would not seek permission to call expert evidence. On the contrary, it's clear from that paragraph that we intended to do so. And as I have shown you, it was made clear in our draft direct expert evidence on the issue of liability.
Mr. Craig?
Madam, he's gone again. Let me just reach him.
He's gone again. Thanks, Ms. Rogers.
May I suggest that he could connect by way of dialing in instead of using the link, because perhaps the internet connection could be an issue?
Thank you, and I agree. I believe he is in fact dialing in, but let me remind him.
Madam, I'm sorry.
We've got you again.
I'm afraid. Yeah, I'm really sorry about this.
That's
I wish there was something I could do about it, but I'm afraid.
Are you dialed in through the link, or are you dialed in by phone?
I'm dialed in by telephone.
By telephone, that's really odd. That's okay, we'll proceed. And if we get interrupted again, we might need to call the IT team, but it doesn't bother me anyway. So you can continue, but I'm sure it's very distracting to you if you're preparing or delivering your submissions. So we were on page 14. You were discussing paragraph 7 of the particulars of claim that your client has submitted.
Yes, and the point I was making was that we didn't say anything there about proving our case. We simply talked about what particulars we would be providing. And there was no implication that we would not be seeking to call expert evidence, as the defendants suggest at paragraph 12 of their skeleton. And on the contrary, it's clear from that paragraph that we intended to call expert evidence, and as I've shown you, it was made clear in our draft directions that there was no need for expert evidence on the issue of liability. And if our position had been that we didn't need expert evidence on any issue, then we would have said so. Madam, that's a minor diversion, but I do so just to address the submission that we've somehow changed our position on expert evidence. And as I say, in any event, even the defendants recognise that expert evidence will be necessary were quantum to be addressed at the same time as liability and injunctive relief. So, Madam, put bluntly, there is no time to build in a quantum trial now, in the absence of any pleaded cases on quantum, in the absence of disclosure, or disclosure, frankly, even having been contemplated, in the absence of witnesses on quantum, in the absence of experts having been instructed, being available or being able to produce reports. And the reality is that if the defendants want to introduce quantum now, then this trial will have to go off until most likely the new year. And I should add that if a trial is to take place on all issues, including quantum, then that will likely add another 3 days to the trial once you factor in factual witnesses, expert witnesses, and submissions. And Madam, just again, a minor diversion, but you may recall that the registry issued a case plan in this case, right at the outset of the case, which envisaged the trial coming on in April next year, with expert evidence following factual evidence in the usual way. And so the suggestion that this case is not being expedited, as I think is being suggested by the defendants in our submission, doesn't stand proper scrutiny. Madam, can I then take you back to our note at paragraph 8?
Yes, thank you.
And we make the point we are already working to a compressed time frame. Pleadings, as I say, closed on the 18th of May when we received the further information from the defendants. Disclosure is coming on the 11th of June in circumstances where we only issued our particulars of claim on the 2nd of March. And we are already dealing with an onerous undertaking in getting this matter ready for trial. And adding quantum now would be a further unnecessary burden. And Madam, we would add, frankly, that the court is also going to be under pressure to deliver a judgment as quickly as possible, given the subject matter of this and that we are holding effectively injunctive relief against the defendant. And that is going to be made considerably more difficult for whichever judge tries this case if he or she has to deal with issues of quantum, which are not straightforward. And Madam, in that regard, can I take you, please, just to remind you of the reasons of His Excellency Justice Al-Madani's judgment in the bundle at page 92.
Yes, thank you.
And Madam, at paragraph 46, you'll see that the court quoted from a judgment of Lord Justice Underhill and Sunrise Brokers and Rogers, in which the Court of Appeal made clear that in cases of this kind, there are evident and grave difficulties in assessing the loss which an employer may suffer from the employee taking work with a competitor. Perhaps I could just ask you just to read the rest of that quotation.
Thank you.
And then, Madam, at page 94, paragraph 48, His Excellency Justice Al-Madani says in the second sentence of that paragraph, there's a risk if Mr. Olayanju continues working for GMG, the claimants will suffer loss and damage, possibly of serious and irreparable magnitude, but at the very least damage which will be difficult to quantify. And Madam, just in the context of the defendant's assertions that they've been keen to get on with things in this case, can I just remind you also of the judge's observations at paragraphs 56 and 57 of his judgment at page 99.
Thank you.
And Madam, you'll recall at the last hearing, we were, of course, content to have a trial at the end of May. It was the defendants who wanted to push the date back. Madam, the defendant suggests that the quantification of damages would be straightforward and easily accommodated in the current timetable. Well, Madam, we say that is contrary to the express findings of this court in this case, as I've just taken you to the paragraphs of the court and its reasons on the interim injunction application. But Madam, in addition to that, the defendants fundamentally misunderstand the difference between heads of loss and quantifying heads of loss. So the defendants say at paragraph 6 of their skeleton argument that the heads of claim, the heads of loss that we claim, are straightforward and not complex. Now that may be right, but the question isn't whether the heads of claim are straightforward. The question is, how does one quantify those heads of claim? And how does one prove them? And those are complex issues as the cases make plain. So the defendants say, can I just give an example of that? Well, they say rather glibly at paragraph 25 of their skeleton argument that lost profits claims are relatively easy to prove because it's just a question of looking at lost revenue minus the costs. But that is a hopeless submission. And can I just give you some examples of what might be needed on a lost profits claim in this arena? First, the court would need to consider historic revenues on our desk, as a desk, not just by reference to individuals. The court would need to consider the revenues made by Mr. Olayanju on the desk. It would need to consider the trajectory of the desk, potentially by reference and of Mr. Olayanju, potentially by reference to others, but also potentially by reference to brokers of a similar level with a similar career path. It would need to consider revenues generated by particular clients. It would need to consider the market since Mr. Olayanju hasn't been working. Has it grown? Has it shrunk? How were ICAP placed in the market? For example, in a bad market with less liquidity, ICAP might do substantially better than its competitors. So you'd potentially have to consider the market as well.
I think we've lost Mr. Craig again, Ms. Rogers.
I think you're right, Madam. He's left you with a cliffhanger. Let me again see if I can trace him.
Thank you.
Madam, I fell off again.
Yes, Mr. Craig, that's okay. I recall
Madam,
at
I
the last
think
hearing this happened. Please go ahead.
No, I'm sorry, Madam, I didn't mean to cut across you.
I was just going to mention that at the last hearing when this happened, I think our IT team looked into it, but it was just a connection issue, so there was nothing that they could do. So I think let's proceed.
Yeah.
And hope for the best, hope that there's no more interruptions. My only worry is that as Ms. Ahmed delivers her submissions, you might be cut off again. But you've got Ms. Rogers in the background who can update you perhaps.
Yes. I've also tried to join using the web app, but I'm told I'm in a virtual lobby.
Okay.
And that the organizer will let me in soon. So it may be I can try. Oh. That's also work. Madam, should I just try?
Yes, please. Let's try that.
Hello, can anyone hear me?
Yes, we can. The voice is not as clear, so I might need to ask you to repeat a couple of things, but let's proceed for now. Thank you, Mr. Craig.
Madam, I'll speak up. Madam, I think the next point I was coming to, just in relation to what would be involved, even in a simple loss, what the defendant says, a simple lost profits claim, one would need to consider the market. Since Mr. Olayanju has not been working, has it grown? Has it shrunk? How were TP ICAP placed in the market? So, for example, in a bad market with less liquidity, TP ICAP might actually do substantially better than others. So, the court and an expert would potentially have to consider the market. So, madam, that's the but-for world. What would have happened but for the breach? But then one also has to look at the actual world. What have we done? What revenues have we generated? Have we had to pull in people from other desks? In which case, what revenues have we lost on those other desks that we would claim from Mr. Olayanju and GMG? And then, madam, if I can ask you just to look at Mr. Berry's witness statement, which is at page 58 of the bundle, for the relevant parts.
Was that page 58?
Yes, please, madam.
Thank you.
A couple of points to make. Firstly, the defendants you'll have seen from their skeleton argument rely upon paragraph 77 and say that paragraph somehow means that we have already undertaken a disclosure exercise on quantum. Madam, I just ask you to read that paragraph, because it's frankly obvious just from reading it that that submission is plainly wrong. Madam, can I also ask you to read paragraph 79 and 80 of that statement? And madam, you'll see one of the points that Mr. Berry makes is that it may be that TP ICAP won't have sufficient resource in the area to service its clients and develop the area of business at all. So that obviously begs the question, well, to what extent, if we have lost revenues, is that because of Mr. Olayanju's breach of contract? Would clients have gone in any event? So difficult issues of causation inevitably arise. But of course, we would also need to see disclosure on GMG's Africa business. How has their business developed? What insights do we get from that in the actual world? Have they increased their market share? Was that because Mr. Olayanju joined them and such like? And madam, the defendants repeatedly say that we're talking here about 18 months loss because we're concerned in this case with 12 months notice and 6 months post-termination restraint. You see that at paragraph 7A and 27 of their skeleton, but that is, again, just wrong. Mr. Olayanju stopped working in December of 2019. he was contractually committed to my clients until the 30th of April 2022. So we are looking at a period of 28 months of employment before we get to any period of post-termination restraint, which would take the period to nigh on 3 years. But in any event, we might be looking at negotiating damages, which are notoriously difficult to quantify. And there would likely be substantial legal argument about whether such a claim was open to us, given the defendant's submissions at paragraph 28 of their skeleton for this hearing. So that the suggestion that's made that quantum would be straightforward, I'm afraid to say, is simply wrong. And Madam, can I just deal then briefly with the defendant's other submissions? First, it said, this is at paragraph 35A of the claimant of the defendant's skeleton, that there is an overlap of issues because in assessing whether to continue the injunction, the court will be greatly assisted by lost commission, as it said it will allow a useful benchmark to assess whether the claimants are protecting a legitimate business interest. Well, again, I'm afraid to say that is just wrong. Madam, we remind you of the fact that it's the invariable practice of the courts in England to split liability and injunctive relief from quantum. That is because it is clear and obvious that quantum is completely irrelevant to the question of liability and injunctive relief. Madam, that is the position even in restrictive covenant cases, where the question of whether an employer has a legitimate business interest to protect is relevant. That is because the amount of commission that an employee earns is nothing to the point of whether the employer has a legitimate business interest to protect. It is well established that customer connection is an established legitimate interest. But in any event, this is not a restrictive covenant case, and it's a point that the defendants just seem to fail to understand, because one of the points that's made by the defendants in this context is that in these sorts of cases, the court would apply the same policy considerations as restrictive covenants. Madam, can I take you back, please, to the judgment of His Excellency Justice Al-Madani at page 89.
Yes, thank you.
And ask you, please, just to read paragraph 39, which is pretty much the whole page, which makes it absolutely clear that in the sort of case we're talking about here, namely the effect of the enforcement of a notice period rather than a post-termination restraint, issues of legitimate business interest and such like, the issues that would arise on a post-termination restraint case simply do not arise. And the court quoted seemingly with approval from 2 English authorities that make that plain. So can I just ask you to read paragraph 39, please?
Thank you.
So, Madam, you'll see that the court effectively quotes with approval from the 2 authorities in relation to the distinction between the two, and then, of course, says, well, constructive unfair dismissal will be a matter for trial, which, of course, it will be. So this is not a legitimate interest case. It's not a case about post-termination covenant. It's about holding someone to their notice period. And, Madam, we furnished you with a number of recent authorities in relation to that in this arena. 2 cases, Elsevier and Munro and Sunrise Brokers and Rogers, which are directly on point in the sense that they concern the court being asked to restrain an employee from working for a competitor during the currency of their employment, in other words, during their notice period, rather than the enforcement of a post-termination restraint. But also 2 cases, again in the employment arena, the first Argus Media and Halium, and the second Square Global and Leonard, which concern the court being asked to enforce post-termination restraints. And in all of those cases, the courts have listed an expedited trial on issues of liability and injunctive relief only, leaving over the question of damages to another hearing if necessary. Now, Madam, I don't say that because that is the invariable practice of the English court, that is somehow binding on you. But I do make 3 points of principle arising from it. First, the practice recognises that liability and injunctive relief are the matters that need to be determined on an expedited basis. And the practice also recognises that in cases such as these, quantum does not need to be determined on an expedited basis. Secondly, it recognises that there is no difficulty whatsoever in these sorts of cases, whether legally or practically, in splitting liability and quantum. The issues that the court has to decide on liability and injunctive relief are separate and distinct from the issues that the court has to decide on quantum. Madam, I recognise that may be stating the obvious in this arena, but it's important to make the point, given the authorities the defendants rely upon in support of their argument that there should be a trial on all issues. Because the defendants have referred to 2 cases in a completely different arena, namely in competition law, and it's no part of our submission that in competition cases it may not be difficult, or it may be difficult to split liability and quantum. Indeed, the position may be different in other contexts because issues of liability and quantum substantially overlap, so that it's difficult to determine one independently of the other. But that is plainly not this case. And in my submission, and this is my 3rd point of principle, there can be no serious argument against the simple proposition that in this area, issues of liability and injunctive relief are separate and distinct from issues of quantum. And Madam, we sort of repeat effectively as maybe as a 4th point to add, which is the burden on the trial judge, who, as I say, is going to be under considerable pressure to get out of judgment as soon as possible, given that this is a case in which we are holding injunctive relief, and that task is going to be made considerably more difficult if the judge has also to deal with issues of quantum. Madam, the defendant's next point is that introducing quantum now will save time and expense, but that again is just wrong. Indeed, it's completely unreal for all the reasons that I've already set out, because there is no way that this case can be ready for a quantum trial in September. So introducing quantum now will derail the trial and will inevitably lead to delay. But Madam, as for expense, if we win this case and get injunctive relief for the entire period sought for April 2022, it may be that we would not seek damages. That is not uncommon. Or it may be that the parties will simply resolve issues of quantum without needing to trouble the court. And if we lose this case, as the defendants say we will, then quantum simply wouldn't arrive. But the defendants say that we should all spend money on quantum, including forensic accountants now, when that may be completely unnecessary. So far from saving expense, it's going to increase expense. Third, the defendants invite you to take into account the possibility of appeals on liability and quantum, and they say, well, there may be 4 hearings rather than 2. Well, Madam, we respectfully suggest that at this stage the court should case manage the trial and not possible appeals from a trial that may or may not ever materialise. Madam, you'll recall the last time we were before you, the defendants were threatening an appeal as to jurisdiction, but that never materialised. And even if the defendants wanted to appeal, there may or may not be any proper basis for an appeal. The defendants may not be given permission to appeal. But even if they did, there are a number of possible permutations which may then arise. If we were to succeed and were to pursue a damages claim, the defendants could seek to stay the quantum trial pending an appeal, or potentially it could seek to stay an appeal pending a quantum trial. And Madam, in that context, the defendants also say, well, there's a risk of having different judges dealing with liability and quantum. And Madam, we make 2 points about that. First, in principle, that is entirely unproblematic. Indeed, it often happens in this jurisdiction I said this jurisdiction, the English jurisdiction, a High Court judge will often determine issues of liability and injunctive relief, and then the quantum to be determined by a master, where that is in accordance with the overriding objective. But second, equally, where it is in accordance with the overriding objective, there's no reason why the same judge can't deal with issues of quantum having dealt with the issues of liability. Madam, the defendant's next point is about prejudice, but the prejudice in a split trial is almost invariably prejudice to the claimant, because it's the claimants who are kept out of their money for longer. So if there is any prejudice, it's prejudice to my client. Now, the defendant's answer to that, or apparent answer, is to say that he has a counterclaim. But Madam, again, we make 2 points about that. Firstly, it is not actually a counterclaim at all. And can I ask you just to look at the defendant's pleading in that regard? It's at page 33 of the bundle.
I suspect this refers to the undertaking.
Yes,
that was
exactly.
attached to the...
Oh. Sorry, your page 33 is, you say is the undertaking?
My page, no, my page 33 is the counterclaim, but I'm saying that I suspect that the counterclaim refers to the undertaking that was provided in the original freezing order.
Yeah, well, Madam, you're ahead of me. That's exactly right. And that really is our point. So the court granted an interim injunction on our application. The price that we paid for that was that we gave a cross undertaking in damages. So actually, all this counterclaim is saying is that if ultimately the court were to find that the interim order was wrongly made, then the court would have to consider whether the defendant should be compensated for any loss suffered by reason of that injunction having been granted. So it's not a counterclaim, it would just be a claim on the undertaking or on our cross undertaking. And the second point we make is that that assessment necessarily would have to take place after the judgment on liability and injunctive relief, because it would only become relevant at all if we failed in our case. And Madam, one can have that assessment shortly after trial in the usual way. Madam, next it's said by the defendants that the prospects of settlement will be enhanced by having all issues tried together. I'm afraid to say I simply don't understand that. We are dealing here with sophisticated commercial parties. If they want to settle this dispute, then they will. And the idea that it's going to be impacted by whether or not there's a split trial on liability and injunctive relief is unreal. If anything, there is a greater prospect of the parties being able to resolve their differences once the issues of liability and injunctive relief are determined. And then finally, the defendants say, and I think this is the last of the points I need to address, that we have known from a few weeks ago that their position was that we should have a trial on all issues and that we should therefore have gone on with preparing for a quantum trial. But that is another in a litany of unattractive points. That is really no more than a submission that we should have agreed to their position that there should be a trial on all issues, but we don't agree to that. And in any event, it fails to address the points that we've made, including as to the absence of any pleadings that would define the shape of disclosure, the absence of disclosure, the need for expert input, the need for other witness evidence, the need for expert evidence, and such like that, Madam, I won't repeat. So we respectfully submit that the defendant's suggestion that there should be a trial on all issues and that we introduce quantum now, some 12.5 weeks away from trial, is unreal and it's unworkable. And we invite to reject that approach. Madam, that's what we wanted to say, I think, on the question of principle before addressing direction. Can I suggest that we deal with that question of principle in terms of any issue about sort of minutiae and directions, if that's something.
Thank you, Mr. Craig. Ms. Ahmed, are you there?
Yes, hello. Hi. Sorry, I was on mute. My apologies, Madam. Madam, before I start, can I just check the documents that you have before you? in terms of what was filed yesterday. Do you have, for instance, before you the case management information sheet with the enclosures?
I will pull that up right now. Thank you, Ms. Ahmed. Yes, I do.
And the two enclosures were the draft CMC order and a letter that was referred to in the case management information sheet, which is dated the 17th of March.
Having some difficulty pulling them up, but I'm sure they will load shortly. Yes, I do. Thank you very much, Ms. Ahmed.
I'm grateful for that. And of course, you've already indicated that you do have our written submissions as well as the two authorities, the Daimler and the Electrical Waste Authority.
Yes, I do. Thank you.
I'm grateful, Madam. Madam, can I just start by saying that there are only two issues for determination before the court today. And that is whether it is appropriate to have a trial of all the issues, that is liability and quantum, and whether or not that accords with the overriding objective when the court takes into account the various factors that we have enumerated in our written submissions, which I will take you to, but for your reference, they are set out at section D of our written submissions at page 10. And then the second issue, obviously, is the directions that we can follow for the progress of the trial. So those are the two issues before.
There seems to be a bit of an echo in the background of the voice. It sounds like there's some books toppling over or something. I'm not sure if it's coming from your end or from someone else's end, but it's quite distracting.
No, I'm sat in the quiet room, so it's not from my end.
Could I please ask everyone else to put their phones on mute if that has been Okay. Hopefully that resolves it.
Thank you, Madam. So the first point that I was saying, or rather the first issue that is before you to determine is whether or not it's appropriate to have a split trial. Madam, I can still hear the echo, in fact. I don't know.
I can as well, yeah. It might be helpful if... Ms. Ahmed, would you just mute your mic for 1 second so we can identify the source of the echo?
Yes, of course.
Thank you. Right. Ms. Ahmed, I think it might be your microphone because once you muted it, the noise went away. Are you back on unmute now?
I agree. Yeah, no, I agree. Shall I dial in? Do you think that would be helpful? And then maybe
that would be fantastic. Thank you very much.
Yeah,
We'll give you a minute to do that.
Thank you.
Hello.
Yes.
Hello. Good morning.
Good morning.
Yes,
Who are
who's
we
the line?
speaking to?
This is Judge Ali.
Madam, I'm back in the meeting.
Sorry, Judge Ali, could you disconnect to this call and connect to the second link that has been sent?
Okay, for sure. Now, okay. Cheers.
Madam, it's Miss Ahmed here. Am I in the correct
Hi.
room?
Yes. Yes, you are.
I just heard Judge Ali there. I think that might be better.
I think it is. Thank you very much.
Yeah.
Now,
So,
I've
Madam,
been instructed by the registry to adjourn for 5 minutes, and I'm so sorry. I know you've taken the effort to dial back in. Could we adjourn for 5 minutes, please?
yes, of course. When would you like me to dial back in?
In 5 minutes at 11:05 Dubai time.
Yeah, okay, perfect. Thank you.
I'm sorry, Ms. Rogers and Mr. Craig. I'm not sure what time that is London time, but just in 5 minutes
No
time.
trouble at all.
From now.
No problem.
Thank you very much. Thank you.
Thanks.
Good morning, everyone. Thanks, Ms. Ahmed.
Good morning,
I
Madam.
suspect we've got everyone on the line.
Madam, you've got David Craig. I'm not sure whether Ms. Rogers is on.
I am. Thank you, Madam.
Thank you.
Thank you.
And Evershed is online, are they?
Yes, we are,
Yes.
Rebecca. Yes.
Yeah.
Excellent.
I think so.
Okay. I apologise about the short adjournment. There was a slight hiccup where someone else's hearing coincided with this one. But that issue has now been resolved. So, Ms. Ahmed, I'll let you proceed, please. We can start from the top again on the basis that we hadn't yet covered any of your submissions.
I'm grateful, Madam. Starting point was simply this. There are two issues before you today. And the first one is whether it's appropriate to have a trial of all the issues, namely quantum and liability, and whether or not that accords with the overriding objective and the factors that I've enumerated in my written submissions. And just for your reference, that is at page 10, section D. And the second issue is whether the directions that ought to follow once you have decided whether or not there ought to be a split trial or a combined trial. Before I go to my submissions, as a general point, what the claimants appear to be doing this morning is to create a complete smokescreen of complexity, which we say does not simply exist. These are red herrings that have been pointed out by my learned friend. And what we say, and we stand by this, that these are straightforward claims and the quantification of such claims are straightforward too. And I'll be addressing you on the factors that Mr. Gregg set out as to the quantification of the claim later on in my submission. Madam, you have comprehensive submissions, both from my learned friend and from me. No doubt you've had an opportunity to read those. And unless there's specific reference that I'd like to draw your attention to, what I intend to do this morning is address my learned friend's written submissions and go through them paragraph by paragraph to demonstrate why it is both practical and workable to have all issues to be dealt with at one trial. One matter that I will raise before turning to my learned friend's submissions is that it's only today that we hear the reasons as to why the claimants say that this matter isn't appropriate for a combined trial. Before that, and even in my learned friend's submissions, they have given no substantive reasons as to why they say that this matter should be a split trial, apart from practicalities by way of their deficiencies to be able to deal with the case and prepare the case. That's not something or a matter that should be visited on the defendants. It is the wrong approach, because what they've failed to do is grapple with the reasons as to why, in their written submissions in particular, as to why a split trial would give effect to the principles of the overriding objective. And so, Madam, with those general points, if I could just perhaps take you to the claimant's submission. And what we see in these submissions, and as I said, it's only today in oral submissions that my learned friend has actually engaged with the issues as to whether or not it's appropriate to have a split trial. But in these issues, we can see a stark absence of any substantive reason. For instance, until my learned friend's oral submissions, they failed to address issues such as cost, delay, proportionality, use of court's resources, and prejudice. And so that is something that, Madam Registrar, we would invite the court to deal with and to assess when coming to its decision. As I said, I've addressed those factors in my written submission, and I've given you the reference there, section D, page 10 of my submissions. This case, we say, is crying out for a combined trial, because that's the only way in which matters can be dealt with justly and fairly. And I make this point straight away. It would be completely unfair to have the sword of litigation hanging over the defendants any longer than is necessary. And we say that the claimants' arguments that they've made this morning are nothing more than fanciful when you actually break down and analyse what it is that the claim, what the claim for quantum is. And so, Madam, dealing with my learned friend's written submission, if I could invite you to take up his note, Mr. Craig's note.
Yes, thank you.
And I'll deal with paragraph 5. And repeatedly, my learned friend has said that the invariable practice of the courts in England is for cases in this arena to be dealt with by way of a split trial, and he sets out examples in paragraph 6. There is one simple point here. This is a misunderstanding, we say, of the proceedings in this court, in the DISC court. Yes, it might be an invariable practice of the courts of England and Wales to deal with cases in this arena in a particular way. However, it's simply incorrect to say that the DISC courts have significant regard to cases in England and Wales. That's just simply wrong. The DISC courts are independent, they have their own rules, and they've strived for that autonomy, and therefore, given their own rules, their own precedents, and their own jurisprudence, we say that the DISC courts are not bound by the position in or precedents in the UK. Yes, they may be useful by way of interpretation, but the DISC courts have their own autonomy and have their own independence. And in fact, this was a point that was highlighted by former Deputy Chief Justice Chadwick in the case of Karafi when it came to awarding triple damages. And that's also a claim that we make in our counterclaim, which I'll turn to and deal with when we come to the counterclaim. In that case, Karafi counsel attempted to draw comparisons with the English principle of exemplary damages when claiming triple damages. The former Deputy Chief Justice Chadwick dismissed this notion outright, and therefore it's not helpful, we say, for the claimants to cite cases in this arena that are from England and Wales. It's not inevitable that this court will follow UK precedent, and they can be used nothing more than an aid to interpretation. That said, just dealing with the cases in this arena that my learned friend attempts to rely on to say that actually it's not appropriate for cases of this nature to deal with both quantum and liability. Madam, if I can invite you to paragraph 4 of my written submissions at page 2.
Thank you, I've got that.
What we say there, that those cases cited in this arena that only deal with liability can be distinguished with the case that we have here in the DISC courts. And the reason being is this. The cases that are set out at paragraph 6, 1, 2, 3 to 4, it can be said quite properly that those were speedy trials. We say that this is not a speedy trial. It's the DISC court's practice to list ordinary trials within a 6-month time period. There is precedent for that. I've made reference at paragraph 5 of my submissions to the case of Tavira and Repoint, where the case management conference took place in October 2018 and a trial was listed in March 2019. This was some 5 months later, and that dealt with both liability and quantum. And we say that, in fact, there has been ample opportunity within the timetable set for this trial, or proposed for this trial, particularly from the date of commencement of the claim, which was the 24th of February 2020, that there has been no reason why this trial has not been prepared for to deal with both liability and quantum. And I distinguish those cases that have been cited by my learned friend at paragraph 4 of my submissions. Point A deals with Elsevier Limited. That was a claim that was issued on the 4th of June 2014, and the trial commenced on the 9th of July 2014. That's 4 weeks after the claim was issued. And that can be properly characterised as a speedy trial. That's not the case here. The claim, as I said, was issued on the 25th of February, and therefore it's going to be some 7 months from the date that it was issued until the date of the proposed trial. And so by any means we say that this isn't a speedy trial, and therefore there's been ample opportunity within the timetable to deal with all issues. Again, at point B, 4B Sunrise Brokers, the trial came on 8 weeks after the claim was issued, and again, that's a proper characterisation of a speedy trial. Point C, Squared Global Limited, the claim was issued on the 4th of December. It was heard 3 months after. This is not the case here. We have had nearly 7 months for all parties to prepare all issues for the trial, and therefore we say there's been ample opportunity within the timetable provided for both claimants and defendants to ensure that all issues have been prepared for. Now, if the claimants have not prepared for issues, then that should not be visited on the defendants, particularly because we say that it would cause them extreme prejudice if issues of both liability and quantum were not dealt with together.
Now, just a quick question, Mr. Ahmed. When there was discussion about the trial being held in, I think it was May, that was the original date that was discussed, and then there was a fair bit of toing and froing. I think I'm relying on memory here, but it was 31st of May or thereabouts. That was the date that was initially agreed. And then there was a further date of June that was agreed. And then I remember that the claimants could not do a trial in August on the basis that their witnesses were not available in the month of August. So that's when we decided that September ought to be the month that trial be listed. What are your submissions in that regard, on the basis that had this trial taken place in June, would your submissions be different in respect to whether this is a speedy trial?
No, not at all, because we've always proceeded on the basis that this is going to be a combined trial, and I deal with the correspondence point. Well, firstly, what we say is that the correspondence is not helpful and it's not helpful to trawl through it, particularly because my learned friend accepts that there may have been a misunderstanding on both parties. So we say it's not helpful to the issue today, because the issue today has to be before you to determine whether or not it's appropriate, in accordance with the overriding objective, to have a split trial. But in any event, Madam, I deal with the discussions today at page 14 of my skeleton argument. It's at paragraph 36. And what we say, and we do you have that before you, Madam?
I do, thank you. Yes, thank you.
And you have been taken some of this correspondence, but we provide at 36 the correspondence that passed between the parties. And if I can just perhaps take you through that very quickly, I don't intend to go through it because I don't think, as I said, it's helpful to trawl through the correspondence, because it's a position today and whether or not it's appropriate to have a trial of both liability and quantum, and that's the issue today. But in terms of the correspondence that's passed between the parties, on the 17th of March, we wrote to propose directions, and we included a provision for expert reports. On the 23rd of March 2020, and you have references there to the correspondence, the claimants wrote back saying that they saw no reason why expert evidence is required in relation to the issues of liability. We then write back on 25th of March explaining that the expert evidence was suggested by reference to paragraph 40 of the particulars of claim. Paragraph 40 of the particulars of claim, Madam, deals with loss and damage, and you've already been taken to that paragraph by my learned friend. And therefore, it must have been clear that we're not talking about liability, or that proposals made for experts were not in relation to liability, but loss and damage. Now, Madam, it's not for us to tell the claimant how they wish to prove their case. it's a matter for them. And if they say that experts aren't going to be necessary, then it's not something that we are going to be pushing. We're quite happy to omit reference to expert evidence or directions in relation to expert evidence. From our part, and at this stage, we didn't and we don't intend to call expert evidence in terms of our losses, because we can deal with those by way of factual evidence. And it is usual in certain cases for quantum to be determined just by factual evidence. It's not necessary in every case that there ought to be an expert to prove quantum. Page 15 then, at paragraph 36D of our written submissions, if what my learned friend is saying, that at that point it would have been crystallised that they want to only deal with liability, then on the 30th of March, we sent the claimants a list of issues. And in those list of issues, we included loss and damage as an issue to be determined at court at the trial. And so that made it obvious that, in our view, we were contemplating all issues to be dealt with. And that was when we were discussing a trial to take place in May and June. Next piece, the next letter rather, on the 21st of April 2020, we again send the claimant our draft directions. Now, we had received at that point the claimant's draft directions, and we had deleted any reference to there being a split trial, and our directions only referred to a trial. And therefore, it must have been clear that we were contemplating dealing with all issues, including quantum and liability. Point F, on the 23rd of April, the claimants wrote back confirming the directions. Now, again, there is some confusion about what the claimants understood, but in those directions, there was no reference to there being a split trial at all. And so our understanding was that the claimants had agreed that this was going to be a combined trial, because all references to the split trial had been deleted. And the only objection made by the claimants at that point was the trial date, because you'll recall correctly, you've recalled that we wanted it in August and the other side wanted it in September because of witness availability. Then on the 5th of May, the claimants write proposing directions for a split trial. We again write back and delete any reference to the split trial, and it's only then when it transpires around the 12th or the 14th of May that there is a confusion in relation to whether or not this ought to be a split or combined trial. However, notwithstanding that, it's always been in our contemplation that this was going to be a combined trial. And if I may say, if the claimants wanted to have a split trial, then we would say that the onus was on them to have set this out explicitly and to have made it clear, or rather made a request clear, that they wanted this matter to be dealt with by way of a split trial. At no point in time have they ever expressly said, this is a matter that's appropriate for a split trial. At no point in time have they ever set out their reasons as to why they consider this is inappropriate for a split trial. At no point have they tried to convince us that this is appropriate for a split trial. And therefore, if they were contemplating a split trial, then it was for them to request this explicitly, and for them to set out, addressing the factors that I have set out in my written submissions, that set out in the case law as to why we ought to divert from the usual position of having a combined trial in circumstances where this cannot be described as a speedy trial on any analysis. They haven't done that. They've merely alluded to a split trial, and we say that that's simply not enough. And so, Madam, we say that it is the position today. That was the correspondence that passed between the parties. However, that is a diversion, and I think my learned friend accepts that it's a diversion. And actually, the determination for the court today is to weigh up all the factors of time, cost, prejudice, case management, and the overriding objective to determine whether or not this case is appropriate for a split or combined trial. And so, Madam, that's what we say in terms of the correspondence that passed between the parties and the positions that were adopted. If I can then go back to addressing my learned friend's written submissions, the note, I've dealt with paragraph 6. Just turning to paragraph 7.
Paragraph 7.
Paragraph 8. I beg your pardon, Madam. Paragraph 8.
Thank you.
My learned friend seeks to persuade the court that there are good reasons for not taking a course of a combined trial, because again they make the point that this trial's been it's on an expedited basis, and therefore there's compression over many months of a shorter time frame. We say that that's just simply not enough. There's been no assessment of the factors required to be addressed when considering the issue of whether or not there should be a split trial. And again, Madam, it's not unusual or extraordinary for the DIFT court to have a timetable whereby a trial is brought on within 6 or 7 months, also dealing with quantum, also dealing with potentially expert evidence. The court is well familiar in dealing with such matters on short notice, and you will see in my written submissions a reference to the case of Karafi, wherein there was a trial listed for May, and 2 months before the trial, the court ordered expert evidence on quantum, and that is a seriously complex case. That was a case where quantum was assessed, or rather claimed, at $70 million US. This case is nowhere near that, and therefore the complexity that my learned friend seeks to advance simply doesn't exist. Turning then to point 2 of my learned friend's paragraph 8, again, the submission made is embarrassing because it seeks to undermine the competencies and the proficiencies of both the DIFT court and its judges. There is no difficulty in dealing with issues of quantum and liability at the same time. The DIFT court, since its institution, since its provenance for 12, 13, 14 odd years, has been dealing with all of these issues in the round, and therefore it's just simply not credible to say that the judge will be under any sort of pressure in dealing with issues of quantum, particularly where quantum, and again, both the heads of loss and quantification of those losses is pretty straightforward. And in fact, as I said, that it's quite incredible that my learned friend is making that submission. My learned friend at paragraph 8.2 seeks to rely on His Excellency Justice Ali Al-Madni's decision in the interim injunction application, and has cited paragraphs there. He also my learned friend took you to various other paragraphs, but just dealing with the paragraphs that have been cited at paragraph 8.2, which saves us time sort of moving around, we say that this is a bad point because, in fact, it goes against my learned friend and assists us. The first point to be made here is that His Excellency Ali Al-Madani is providing his comments in the context of an interim injunction application. At that point, he doesn't have any evidence. At that point, he doesn't know what the state of play is, and he simply makes comments, general comments, and therefore it's not a question of the defendants going against any express findings. It's simply that judgment was given in a different context without having all of the pleadings, the potential witness statements, the potential aspect of disclosure before the judge there, and therefore we say that that's not a helpful point to make. The second point to be made in terms of the paragraph that's being cited, what His Excellency states is that, and I'm reading from the extract of the judgment that my learned friend has cited in his written submissions. In cases of this kind, there are evident and grave difficulties in assessing the loss which an employer may suffer from the employee taking work to a competitor. Even where it is possible to identify clients who have transferred their business, which will not always be straightforward, particularly where the new employer is outside the jurisdiction. There may be real issues about causation and the related question of the length of period for which the loss of the business could be said to be attributable to the employee's breach. So, Madam, there's a number of points raised by the learned judge in that particular paragraph But in particular, one of the factors that His Excellency Judge Ali Al-Madni refers to is the question of causation and the question of the length of period of loss. Now, my learned friend seeks to persuade you that quantum is a discrete issue, and we say that's not right, because there is some overlap between causation and quantum, and therefore it's not easy to split these issues. So that's the first point that arises out of the paragraph that's been cited. The second point is that my learned friends have said at the bottom of page 3 that damages will be difficult to quantify. Now, just because damages are difficult to quantify doesn't necessarily mean that that is a factor that this court should take into account when deciding whether or not it's in accordance with the overriding objective to split the trial. The claimants have brought this case in the DISC court, and if in bringing this case, they should have been prepared to deal with all issues at any points in time. And therefore we say that difficulties to quantification shouldn't be a relevant factor, nor is it a relevant factor for your consideration today. In terms of the remainder or the balance of the paragraph cited by my learned friend, we don't agree that sorry, I beg your pardon. In terms of the passage that's been cited by my learned friend, there are a number of points that have been made there in that paragraph, and that is the employee taking work to a competitor, and it's impossible to identify clients who've transferred their business. And this goes to the factors that have been enumerated by my learned friend in relation to the difficulties that he says arise out of quantifying the claim. Again, this is the point that I made at the start of my submissions, that this is a complete smokescreen. And actually, when you undertake an analysis of those factors, one reaches the conclusion that it is not as significant or as substantial as my learned friend would, or the picture that my learned friend is attempting to paint. But the first point to make in this regard, in terms of the quantification of damages, and we say it is straightforward, is that this isn't a trial of two corporate entities where there's going to be voluminous amount of disclosure, there's going to be lots of number crunching, where there is going to be a huge level of damages that are going to be claimed. This is a claim of a corporate entity against a former employee and a former junior broker and another corporate entity, albeit smaller in size. In terms of the claim against the former employee, as I've said, it's disingenuous to say that the factors that go to quantification give rise to it being a significant or substantial exercise. And we say that the factors that have been enumerated by my learned friend are, in fact, when looked at, irrelevant. And if I can perhaps go to those factors, there are three heads of loss here. The first one is the loss of commission, second one is negotiating damages, and the third one is the loss of management time. In terms of the loss of commission, the factors that my learned friend says make this a very difficult exercise is firstly the historical revenue on the desk. It's not relevant to look at the historical revenue on the desk. We're not talking about the losses of the desk itself. We're talking about losses by reference to Mr. Olayanju's performance on that desk. So historical revenue is neither here nor there. It is the revenue that Mr. Olayanju would have generated as a result of remaining on the desk or subsisting as an employee. And to that extent, Madam, if I could just perhaps refer you to Andrew Berry's second witness statement, which my learned friend has already taken you to. It's at page 57 of the CMC bundle.
Bear with me, please. Thank you, Ms. Ahmed, I've got that.
And so paragraph 77, second sentence, I've been provided with figures from ICAP's Management Information Division. So there is an information division clearly that records and collates all of this data in relation to revenue generated. And it's important that we recognise that this is data that is easily available, it's easily identifiable. It's not data wherein the claimants have to trawl through people's inboxes and emails. It is available, not least because the organisation, TP ICAP, would need to assess the commission generated by the trades made by the brokers, but also they would need to determine bonuses payable to the brokers, and bonuses are paid on a quarterly basis based on the revenue that's generated, and therefore that information, that data, we say is readily available. In addition, just to make this point, can I just take you back, Madam, to paragraph 58 of this witness statement?
Yes. Thank you.
So, paragraph 58 is the 6th of February, whereby an employee of TP ICAP called GMG's officers, and it was confirmed that Mr. Olayanju was working for GMG, and we see that the next paragraph, it confirms what was strongly suspected. So the confirmation of Mr. Olayanju working for GMG was on the 6th of February. This witness statement is dated the 25th of February. And therefore, this information is available and was available to the claimants in a very short period of time. And therefore, we say that it's a complete smokescreen for my learner friend to say, well, it's so difficult to garner this information. We haven't been concentrating on it. It's just, we say, disingenuous. Coming back then to paragraph 77.
Thank you.
So I've been provided with figures from TP ICAP's Management Information Division. When Mr. Olayanju was on the early career program, his cost to the business was almost 140,000, while the revenue he generated was approximately 10,000. Similarly, as a trainee broker, his cost to the business was over 170,000, while the revenue he generated was around 130,000. So historically, Mr. Olayanju wasn't performing on the desk and he wasn't generating any revenue. And to say that you need to look at the desk is we say, irrelevant. That's not a relevant consideration. It's Mr. Olayanju's performance on that desk. The next sentence and the final sentence in paragraph 77, the figures only began to tip in favour of the business in 2019 when Mr. Olayanju became a broker. Mr. Olayanju became a broker on the 1st of May 2019, and therefore we say that at that point profits were generated or commission were generated, and that's the starting point by which any loss would be determined. The next point my learned friend says that you would have to consider when quantifying these damages revenue made by Mr. Olayanju. We say that is correct, but again, the period of time from which he was generating revenue, we see from there, was the 1st of May 2019. He resigned on the 19th of December 2019. The next point that my learned friend mentioned in relation to quantifying damages was the trajectory of the desk. This is again a matter that's been dealt with by Mr. Andrew Berry in his second witness statement. If I can refer to paragraph 79, and it's halfway down the paragraph.
Yes.
Well, actually, we can start from the start of the paragraph. TP ICAP is now exposed to the real and immediate risk of loss of its clients and business, specifically the niche African products, which form the bulk of Mr. Olayanju's client base. Pausing there a second, this is an assessment of the entirety of the organisation where revenues were lost. This is very specific to one desk, the Africa desk. And on that desk, there were two people working, Mr. Olayanju and his colleague, Mr. Opoku. And so therefore, again, that narrows the scope of any assessment of quantification. If we then move to, again, halfway down this paragraph, starting in 2019. In 2019, Mr. Olayanju generated almost £360,000 worth of revenue for the business, an increase from £131,000 the previous year. There was every expectation that this figure would increase significantly year on year as he consolidated and developed this area of business. And so that refers to the trajectory. However, the trajectory would have been paused by fact that Mr. Olayanju did give notice. And whether or not that notice was because he considered himself constructively unfairly dismissed, or notice in the ordinary sense, that notice still stands. And therefore the notice period from the 19th of December is the 12th of, it's 12 months. And therefore we say, despite what my learned friend is saying that loss is for 36 months, we say that that loss would only be for the 12-month period, reflecting his notice period. And so very limited loss. In terms of the next factor referred to by my learned friend, that any assessment of quantification would have to consider the market. We say that that's not relevant. It's not a consideration of the market. It's a consideration of Mr. Olayanju's performance, and for his performance on that desk, on the Africa desk, for that very limited period of time. The final point that my learned friend was there would have to be an assessment of pulling people from other desks. Well, we know that no other person was pulled from any other desk. And the reason why we say that is because, firstly, there was a senior broker who was already in situ, Mr. Glenn Opoku, who was Mr. Olayanju's colleague. He was a senior broker. He was already there. And two people replaced Mr. Olayanju, Mr. Cribb and Mr. Kurefa, who started with the claimants at the beginning of December. And therefore, there is simply no evidence to say that other people were pulled off the desk. And therefore, we say, in that context, that it's simply a smokescreen for my learned friend to suggest that there are all of these factors that will go into assessing loss. We say that there is nothing of the sort there. And this is quite a straightforward exercise to quantify, and in any event can also be done on factual evidence. It's not always necessary to have experts on that issue. In terms of the other two heads of damages, negotiating damages of loss and management time, my learned friend has failed to say what sort of evidence will be required for negotiating damages. We say that this is simply a legal submission that both parties would make to the court, because these are notional damages in a hypothetical situation where both parties may have negotiated the end of the contract, and therefore this is limited to legal submissions rather than any sort of factual or expert evidence. In terms of loss of management time, well, that would be that an expert doesn't need to opine on that, and that's simply factual evidence. And therefore we say that there's losses of about 1 year, there's losses incurred by one employee, losses on one desk as opposed to the entirety of the organisation. And in those circumstances, it's extraordinary that my learned friend is saying that they just won't be able to meet any trial timetables, particularly given the number of lawyers that are working on this case, and also by reference to past precedent as to how the DISD court has dealt with provision of expert opinion, and it can be done within a short space of time, as we saw in the Karafi case. And therefore, it's just simply not credible to say that it's not practical to instruct an expert now. We, as I've mentioned in my written submissions, have made inquiries of experts and given them the parameters of the case, and we have been told that it will be relatively easy to put forward an expert report in a relatively short time, and therefore there's no reason, no substantive reason, in the absence of any inquiry by the claimants, as to why they would not be able to meet a provision to provide expert reports if they wanted to do that, if they thought it necessary to do so. Then in terms of the next point, and I think I've dealt with as well in my submissions now, paragraph 8.3 as well over the page, in part. We say there is one more critical fundamental issue here as well in terms of why it's not appropriate to split the trial, the liability and quantum. The reason why we say this is that, and my learned friend has made submissions that we are wrong, and I say that that's just simply not right, and that is a submission that we would be making to the court. And if I can, Madam, invite you to turn up paragraph 11, sorry, section C, paragraph, page 4 rather, if we start from page 4.
Okay,
section
thank you.
C. Section C deals with the damages claim. And I don't intend to go through all of that section, but I just do want to refer to one point that my learned friend made in respect of there being a distinction between notice periods and restrictive covenants. And I deal with this at paragraph 15 of my written submissions. We are not advancing a case that there is no distinction. However, the case that we are saying, or the case that we will be putting, is that historically employers have attempted to circumvent difficulties in enforcing restrictive covenants. That's why time and time again you see provision of long notice periods. However, it is still open to the court to determine whether or not the notice period or the length of notice period is open to abuse, or whether in fact it is to protect a legitimate business interest. And that is an issue that the court can determine. In terms of protect, and we say that the same policy considerations arise between the length of a restrictive period, restrictive covenant, and a notice period, and we say that the length of the notice period is an abuse by the claimant, particularly, and therefore the injunction, and it connects with the injunction, and therefore the injunction that's been obtained, again, should not have been provided, particularly because there is no evidence as yet that the claimants are protecting a legitimate business interest. Now, one way of establishing that they have a legitimate business interest to be protected is if the second defendant, if Mr. Olayanju, had taken away any confidential information. Now, whilst this has been suggested in pleadings that he may have done, however, there is no evidence, there is no explicit overt evidence, and no evidence has been put forward by the claimant that Mr. Olayanju has taken any confidential information. And in those circumstances, we would say that the claimants are protecting a legitimate business interest, but in fact what they are attempting to do is stifle competition, which is something that is frowned upon by the courts, and therefore we do make that distinction there. And in that context, it would be appropriate for the court to have before it evidence in relation to loss, because we say that the measure of any damage refers directly to whether or not it was appropriate or is appropriate for an injunction to continue or to be granted. And therefore we say that without that sort of evidence, the court is hindered in its ability to be able to determine whether or not the claimants are in fact protecting a legitimate business interest, or whether or not this is simply a vendetta by the claimants to try and keep Mr. Olayanju out of the market. And we say that is what it is. And so we say that is why it's important for the loss evidence to be before the court when it comes to deciding the issue of liability. In terms of then moving back to my learned friend's written submission. Paragraph 8.3, and just dealing with the last point that's being made there. If the court's grant injunctive relief for the full period sought by the employer and the employer then decides not to pursue any damages claim, we say that that's a rather partisan and one-sided view to be taken by the claimants, and it openly demonstrates what we say is the shameful approach by the claimants to this litigation, and that is that this is simply a vendetta litigation whereby they are braying for blood to keep Mr. Olayanju out of the market, and this is a clear demonstration of that. Their objective is to punish Mr. Olayanju by keeping him out of the market, and we say that they're prepared to do that at all costs, even if that means not complying with any preparation that they ought to have done for all issues in the claim, and therefore they're quite happy for this matter to be to only deal with liability and then decide whether or not they want to pursue for damages. But that's not the way in which we say that litigation ought to be approached, and that's not something that is just unfair to the defendants, because that will also mean that costs are run up. If there are two trials, inevitably costs will run up, not least in relation to preparing for two separate trials, but also in relation to legal fees, the court's resources, the judge's time. And again, I'll go through those factors later in my submissions. But more importantly, it will mean that Mr. Olayanju has to suffer even more hardship, particularly because he's not being paid at the moment. And I've made reference to that in my written submissions as to the hardship that's being caused to Mr. Olayanju in particular. What my learned friend fails to do at paragraph 8.3 is to provide an alternative scenario whereby the defendants may win. And if they do win, we say that they will be deprived of the damages. Now, there's been some debate about whether or not that's just enforcement of the undertakings provided in the interim injunction, or whether or not it's a counterclaim. Either way, there will have to be, even if it is an enforcement of the undertakings, then there will still have to be an assessment of the losses suffered by the defendants. The first defendant's losses are for loss of profit, disruption to business, loss of management time. There will have to be an assessment of that. The second defendant's losses are salary. Again, that's still not being paid. But in any event, that is not simply rather the claim doesn't stop there, because both defendants are making a claim for triple damages. And the only way in which that claim, a statutory claim, could have been made is by way of a counterclaim. And so there has to be, and there will be, an assessment of damages. Now, my learned friend is quite dismissive of the defendant's claims for damages and saying, well, that can be brought on very quickly and the court can hear it very quickly. But that's said without any substantiation whatsoever, because, again, the defendants would have to prepare, again, for a trial of quantum, dealing with quantum. They'd have to put together, there is no guarantee as to when the court would be able to list such a trial. My learned friend says, well, different judges can deal with matters independently. We say that is a burden on the judges, because a separate judge would have to then read into the judgment and read into the papers, and therefore that is a burden on the resources of the court. And therefore we say that hardship to the defendants ought to be taken into account when deciding whether or not it's appropriate to have a split trial.
Ms. Ahmed, just a quick question here. The counterclaim, as so described in the defence, is occasioned by the filing of the claim form and the injunctive relief sought by the claimant. In other words, what I'm trying to say is that had the injunctive relief not been sought by the claimant, your client would not be seeking the counterclaim. Is that correct?
Yes, but the counterclaim also makes the claim for statutory loss of triple damages, which I don't think is covered by the undertakings.
Can you walk me through that briefly, please?
Well, the undertakings provide for loss and damage. I mean, let me just bring up the undertakings and say. The undertaking provides that the defendant should be compensated for the loss if the court was wrong in giving the injunction. Those are losses that arise, you're absolutely right, arise out of the claim. However, in terms of the counterclaim, there is also an additional statutory loss. And that statutory loss, whether or not, there's a question of whether or not it would be claimable under the undertakings, is an issue, which is why it's been brought as a counterclaim.
Okay, I'm just trying to get my head around that. Carry on, perhaps, and then if I've got further questions, I can raise them at the end.
Well, just taking it in stages, the claimant's undertaking is that if the court later finds that the injunctions or undertakings have caused loss, then that loss then the defendants ought to be compensated for the loss. And that would cover, obviously, loss of salary, loss of commission to the second defendant, and any other losses suffered. So those are the quantifiable damages, if you like. However,
but the statutory loss, and sorry to interrupt you, the statutory loss is also occasioned by the filing of the injunctive relief.
But the statutory loss is the triple damages is not easily quantifiable because it requires an assessment of the court as to whether or not there's been conduct that's been so egregious as to warrant a claim for triple damages. So that wouldn't automatically fall within the undertakings.
Correct, but it's still.
So that's why that's part of the
counterclaim of the claim. Yeah. Okay.
So
I think my question's been answered.
Yeah, but whichever way we look at it, madam, there has to be an assessment of the losses that have been occasioned by the defendants, and therefore, it's like I said, Mr. Craig seems to be dismissive of the fact that this can take place after the trial of liability, but there's no reason why the defendants should be kept out of their money, particularly because of the financial hardship that's been suffered by the second defendant. There is no good reason as to why he should wait another 2 or 3 months for a trial of quantum to come on and to pay for preparation of that trial, particularly where if the court finds that this injunction shouldn't have been granted and that he is entitled to work. And so it potentially has the effect of stifling the defence because the second defendant, he's an individual, he has to pay for his legal representation, and therefore it places a huge and extreme financial burden on him to do that. And we say that this is an antithesis of the spirit of the overriding objective, and there's no good reason as to why Mr. Olayanju should be kept out of his money. And so we say that it's not appropriate, therefore, to just simply say, well, the trial of quantum can happen at a later stage, given the effect and the impact on the second defendant in particular.
Well, why can't the second defendant pursue its counterclaim irrespective of whether the claimant pursues its quantum claim at the first trial, in the event that that's how ISO directs?
Because if you direct a split trial, then that would mean that the court has to decide the issue of liability first for both parties, or for both parties' cases, and then at a later stage decide the issue of quantum in respect of both parties' claims for quantum.
I disagree. I think that if you wish to quantify any damages suffered by your client, either through the statutory loss or through the undertaking that was provided by the claimant, I don't see difficulty in doing that immediately after the liability trial. I could be wrong, and I'm prepared to hear your submissions in that regard. What I do see, however, is that in the event that the claimant was successful in its quantum case, it just wouldn't be, and it could be the case that the claimant is entitled to more money than the defendant, for example. It just means that the claimant would not be entitled to a right of set-off. So there's nothing preventing your client from pursuing what they are owed immediately after the liability hearing, if that's the way we proceed. And the claimant would then have to...
Sorry, I beg your pardon.
Sorry, Ms. Ahmed, yeah. So I was saying the claimant would then owe certain money, for example, to the defendants in the event that the defendants are successful in their statutory loss / undertaking case. But then no right of set-off would be available for the claimants at that stage because there's nothing to set off against. So unless you've got, and as I said, I'm prepared to hear your submission.
Yeah.
Go ahead.
So if I understand the approach that you are suggesting is that the defendants deal with quantum at the trial that's been proposed in September, but the claimants are given an opportunity to hold off their ability to deal with quantum until a later stage.
Correct, because I see them as being mutually exclusive. I think the heads of damage are very different. So I see them as being mutually exclusive, and I think that the defendant could pursue a counterclaim at the liability trial or soon thereafter. It might be the case that...
Well, the first defendant's damages aren't any different to the claimant's damages, because the first defendant is also claiming loss of commission. It's also claiming disruption to the business, and it's also claiming loss of management time. The only difference between the two heads of damages, or the heads of damages between the two parties, is that the claimants are claiming negotiating damages, whereas the first defendant isn't. And in terms of the negotiating damages, that's a question of a legal submission in any event. And so it would be slightly unfair if one party has to prove its quantum claim, but the other party doesn't.
But that's a choice available to it, is the point I'm trying to make, because you cannot, my current thought at this stage is that you cannot compel someone to push, or you can't push them to file a relevant claim if they don't wish to do so. So if, and I'm hearing the claimant in that they're saying, we might not wish to pursue the damages claim after the liability trial takes place. So for us to push them and to say, no, you will claim quantum and you will assess those damages before the liability trial goes ahead, so that you're then dealing with liability and quantum at the same hearing. I don't think that's very fair, because you can't, you know, absent any limitation of time statute, for example, you can't compel someone to file a case or to file their case within a particular period of time. It could have been the case that the claimant filed their liability claim form very separate to the quantum claim form, and I do agree with what you're saying in that it wasn't so well articulated. The claim form that was filed and the particulars that were filed, it was a hit and miss. It kind of said, we might be dealing with quantum, but we don't really know. And we'll realise whether we want to make the quantum claim as and when the evidence surfaces. On that basis, I'm still not quite convinced that that meant that they had wished to deal with quantum at the outset and immediately after the issue of liability has been determined, i.e. at the same trial. I'm giving you my thoughts so that if you've got further submissions in that regard, I'm taking on board, and I was waiting for you to finish.
But my response to that is that it's not open to claimants to hedge their bets about what they want to do. Either they make the claim or they don't make their claim. And this is the whole purpose of pleadings, because they have actually made a claim for damages. And therefore, the question is it's not a question of whether or not they have or have not made the claim. We say they have made the claim. And if they have made the claim, they should be prepared to pursue it, unless on the authorities, it's against the overriding objective for the court to only deal with liability. And the only point that's been made by my learned friends so far is the practicality of dealing with the claim. And they talk about that at paragraph 9 of their written submissions, and they make 7 or 8 points. But in all of those 7 points, what they effectively have said that we haven't had time to deal with the claim, or there's been deficiencies in our preparation. Well, if there's been deficiencies in their preparation, why should that be visited on the defendants? It's unfair for them to deal with this. Well, it's unfair for them to be uncertain about the case that they have to meet. As far as they're concerned, the case has been pleaded. It's been pleaded in full. There is a claim for loss and damages, and therefore it's unfair for the defendants to not to know whether or not, in fact, these damages claim is being pursued against them, firstly. Secondly, if it is being pursued and the defendants haven't said in terms that they will not pursue, they've simply said, well, we'll take a position as and whenever we decide. But if they are going to pursue a claim for damages, then it puts the defendants in an invidious position whereby they have to fork out for potentially 2 trials, potentially 2 appeals, potentially a whole load of costs that are doubled up because the claimants have failed to deal with preparing for the claim that they have pleaded, and therefore if they have pleaded it, unless they withdraw that claim, then they are compelled to pursue it, and they are compelled to provide damages or evidence for those damages if they want to prove that claim. And so we say that the correct prism through which this ought to be determined is, again, whether or not it's in accordance with the overriding objective to split these trials into both liability and quantum. I hope I've answered your question there, because, I'd like to move on to paragraph 9 of my learned friend submissions, which deals with the practicalities, and it's a submission that my learned friend made this morning as well. So, Madam, I hope I've responded to the question. Was there anything else at that point?
No, please carry on, Ms. Ahmed. Thank you.
In terms of the practicality, the first point that they make is that there's been no pleadings as to quantum. Well, that's not correct. There are pleadings. They've filed their particulars of claim. Paragraph 40 deals with their heads of loss and damages, and it's sufficient enough for the defendants to understand what the case is in terms of their heads of claim. In relation to quantification, well, it's a matter for the claimants to quantify their claim and to prove their claim. It's tried law that it's for the claimants to prove their claim and for the defendants to raise arguments in relation to, let's say, mitigation, for instance, or whether or not the assessment is correct. But that doesn't need extensive pleading. And nor is it the practice of the DIFC courts to have schedules and counter schedules. And therefore we say that's another smokescreen raised by the claimants to paint a picture of complexity and why they don't want to pursue a claim for damages. The second point that they make is that the claimants have undertaken no disclosure searches in relation to quantum. Well, again, that's a matter for them. It's for them to pursue their case. It's for them to prove their case. In any event, in terms of the disclosure searches that may have been undertaken, we say that the majority of the work would have been done in March or April, because the first defendant issued a data subject access request on the 13th of January. That was responded to. We received nearly 10 lever arch files, and therefore we say that the majority of the preparation for disclosure had already been done, and it's unlikely that there is going to be any more disclosure than that produced by the DSAR's request. And therefore we say that disclosure, the disclosure exercise, or rather the disclosure, has already been prepared. The claimants were aware at the latest on their case that we wanted a combined trial. That was on the 14th of May. That's that's given them 4 weeks, nearly 4 weeks in which to be able to garner any documents in relation to disclosure. And in any event, we say that Mr. Andrew Berry's second witness statement demonstrates that work has been undertaken in terms of any disclosure that might be required. And in any event, it's easily identifiable and readily available as well. And so we say that that's another smokescreen and disingenuous attempt to try and add complexity as to why it's not practical to meet a timetable. The third point that they make in relation to quantification of the claim, well, I've already addressed you on that. This is a simple claim, we say. The losses are of a limited period. The scope of any quantification is limited. We're dealing with one employee over 1 year in relation to revenues generated on one desk. I mean, if they can't quantify that claim, then it begs the question that what has been happening since they've been pursuing the claim, since they've been issuing the claim. And as I said, any lack of preparation on their part and deficiencies on their part ought not to be visited on the defendants. In terms of point 4, in relation to quantum searches and so forth, again, it's not difficult to be able to propose what the parameters of any quantum search ought to be, nor is it difficult to instruct an expert at this stage. I've already mentioned the case of Krafi. 2 months before trial, an expert evidence or permission for expert evidence was provided, and if in that case of such complexity, both legal and quantum, the court ordered an expert to give an opinion, then we see no good reason as to why that is not something that can't happen in this case. And we again make the point that it is a straightforward issue that needs to be determined. Point 5, in terms of the confidentiality protocol, again, Malone Friend seeks to use this to persuade the court that there is some level of complexity in agreeing a confidentiality protocol. We say no such complexity exists. There's no reason why if that is necessary, it can't be done even now at the CMC or by way of correspondence. In any event, this is a public matter. It's in the public domain. In the interest of open justice, there's no reason why a confidentiality protocol ought to be agreed, because it offends the issues, or rather it offends the principles of open justice. And if they want a confidentiality protocol, then that's something that can be, then that's something that they can write to us about and we can agree. But at this point in time, there's no hindrance as to why any confidentiality protocol means that it's not practical for the court to deal with the issue of quantum. Point 6, they talk about witness statements. Again, the reference there we say is vague, it's wishy-washy. They haven't told us any information about witness availability. They haven't provided any information as to who the witnesses may be. In any event, in terms of the witness evidence for quantum, we say that that's not going to be significant and it's not going to be substantial. The issues of quantum are relatively straightforward, we say, and we keep repeating that. And in any event, at last count, when the last cost statement was filed, there's nearly 9 lawyers working on this case, and therefore within those 9 lawyers, there must be some ability for somebody to be able to put together a witness statement on quantum. In terms of expert evidence, I've already addressed you on that. That's point 7. As I said, this is absent any inquiries by the claimants. In fact, we have made inquiries of experts, and we have been informed quite reliably that if there was a need for an expert report to be provided on an area of lost commission, then that would be relatively easy and could be done within a matter of 2 to 3 weeks. So, Madam, we say that the points that have been put forward in terms of all the the points that 7 points have been put forward, these refer to the deficiencies of the claimants in their own preparation. They don't actually grapple with the issue, and that is whether or not it's in accordance with the overriding objective to split the trial. Point 8, the trial has been estimated for 5 days. We consider that there is ample opportunity for the court to deal with both liability and quantum. In any event, if the claimants wanted to have extra time, and again, subject to the court's approval, there's no reason why we couldn't add a couple of days to the trial. But there is no evidence to say that the proposed trial date will be derailed. There is no trial date at the moment. A trial date has been proposed for the 6th of September. But in any event, there is no real evidence as to why ordering a combined trial would derail the trial timetable. And so, Madam, those are my submissions in relation to the claimant's written submissions. The final point that we would make is in relation to paragraph 13, which is the last paragraph of the skeleton argument. And we say that the claimants have attempted to paint a picture that it would involve significant and substantial work, and in our submission we say that that is over-exaggerated and it's complete hyperbole. In any trial, expert reports are part and parcel of a trial preparation, and to say that expert reports are a distraction, because I think that's been mentioned somewhere, is just, it's laughable, we say, considering the amount of resources that are being thrown by the claimants to this case. Given the amount of resources that are being thrown, given the notion put forward by the claimant that, in fact, they may not even pursue a damages claim, we say that this exercise is simply an exercise to punish the defendant, and to have two separate trials, would again further that objective of punishing the second defendant in particular for leaving the employment of the claimant, because all that will seek to do is increase the hardship and the financial burden on the second claimant, and therefore, on the second defendant, and therefore we say that in the interest of the overriding objective, this ought to be a combined trial. And just, Madam, for your reference, can I invite you to turn up section D of my written submission, page 10. Thank you. The most recent authority on this area is the Daimler Authority, which cites electrical waste recycling, which set out a list of relevant factors and taken into account pragmatic balancing exercise and how a case is likely to unfold. And at paragraph 35, Madam, I've set out the factors that the court ought to take into account when deciding whether or not to order a split or combined trial. And just very quickly taking you through those factors, 35A is an overlap of issues, and we say there is an overlap of issue because the loss suffered by the claimant will provide the court a benchmark as to whether or not the injunction ought to continue, because it protects, in fact, it's protecting a legitimate business interest. So we say that is an overlap. The point B at 11. Page 11, paragraph 35B, the saving of the time and expense. Again, we've dealt with that in some length there, but effectively the point that's being made is that there will be no significant time or cost saving if there are two trials. In fact, if anything, it will increase costs and it will increase time. And my learned friend has put forward no evidence that there will be any cost savings or time savings. Point C deals with trial preparation and management. Again, we refer to the legal team deployed by the claimants, and therefore we say that given the size of the legal team, that there ought to be no hindrances to the preparation required, whether it be by way of dealing with an expert or whether it be by way of putting together factual evidence, that they have sufficient resources to be able to throw at this, not least because when one looks at the cost statements, the costs that are being incurred, and one example is if you have the case management information sheet before you, the claimant's cost of just production of documents is $155,000 as compared with the defendant's costs, which are 100,000 dirhams. And therefore, given the significant resources, unwarranted significant resources that are being thrown at this by the claimants, there is no real excuse as to why they won't be able to meet any timetable if the court was minded to say that this is a combined trial and that issues of liability and quantum ought to be decided together. Then point C over the page at 13. This refers to the potential prejudice to the defendant. And that's already been, I've already made submissions about that. And in particular, we say that because D2 is not being paid a salary at present, if the claimants are hedging their bets as to whether or not they are going to pursue a claim for damages, then we say that that the second defendant either ought to be paid or ought to be compensated by way of an interim payment. And as Madam, you've said, that if the claimants are hedging their bets, then obviously they may lose the right to settle. Well, if they are hedging their bets, then that must come at a cost to prevent any prejudice being caused to the second defendant, because we keep making this point, there is significant hardship on him. Had this been a speedy trial, then of course all of those issues would have been dealt with relatively quickly, but they haven't. He resigned on the 19th of December and the trial has now been stretched out to September. And so one would have to consider, if the claimants weren't prepared to meet their case or pursue their case on damages, then one would have to consider the status of the injunction against the second defendant. In terms of settlement, point E, page 14, we say that not having all the issues before the defendant, not being certain about the claims that are being brought, not being certain about the damages that are being pursued, makes it extraordinarily difficult for any negotiations on settlement to take place. And this in itself is against the overriding objective. The IFC courts are eager and trying to persuade parties to settle their cases and their disputes amicably. And without knowing the extent of the damages being claimed by the claimants, it would be very difficult for any settlement negotiations to take place and for any settlement to happen. And therefore, we say that that ought to be another critical consideration for this court when coming to determine whether or not it should be a split trial. So, Madam, those are my submissions as to the principle of whether or not there ought to be a split trial. There is a draft CMC order that we have filed, and depending upon the approach that you want to take, if we can perhaps take a few seconds to consider that order.
That's fine. When was it filed, Ms. Ahmed?
It was filed with a case management information sheet. It was one of the enclosures.
I've got it, thank you.
Yeah. So what we have done is we have provided a draft CMC order, and paragraph 1 deals with disclosure. Now, this is disclosure in accordance with the civil procedure rules as opposed to the RDC, because it was contemplated that this would be a speedy trial and that it would be easier to deal with disclosure applying the CPR. But in any event, the date that has been provisionally agreed for disclosure is the 11th of June. If the claimants wanted extra time, and we say that they ought not to be given extra time because they should have prepared their case right from the start when they commenced proceedings, but if in the event that the court is mindful to give them extra time, then there's no reason why a week can't be factored into the timetable, which is the reason why the 18th of June is in square brackets there. Paragraphs 2 to 4 deal with witness statements. My learned friend hasn't made any oral submissions about those, but those are the dates that we say would be workable around both parties' commitments. There's been a provision provided for expert evidence. Now, I'm not sure whether my learned friend was making some criticism as to this appearing all of a sudden now, but the reason why it appears is because this issue as to whether or not there ought to be a split trial has been crystallised, and it was only crystallised around the 14th of May. But in any event, there is provision within the timetable for the instruction of a forensic accountant. My learned friend seems to think that this would be dependent on factual evidence. We say that that's not right, because the loss of opportunity or the loss of commission, loss of revenue claim is dependent upon data that the claimants can provide. There's no reference to any factual evidence, and factual evidence won't be necessary. In any event, even if I'm wrong and factual evidence might be relevant, then the main witness statements are to be exchanged on the 6th of August 2020, and that would be the bulk of the factual evidence. And therefore, if witness statements are exchanged on the 6th of August, then there's no reason why those witness statements can't be provided to the experts to consider whether or not it changes their opinion, and there's no reason why a supplemental report can't be factored into the timetable as it stands. Then the next section is trial bundles. I don't think there's any controversy there. Skeleton arguments, and of course, provision for a trial. Madam Deputy Registrar, those would be our proposed directions and recommendations. Is there any issue that I can assist with, or any other question that you'd like me to respond to?
Not at this stage. I'm wondering whether Mr. Craig has any further submissions to make. He might not need to, but I just want to give him the opportunity in the event he's got reply submissions to raise.
Madam, yeah, can I just make a few, because there are so many heresies of law and so many misrepresentations, one anticipates entirely innocently, in Ms. Ahmed's submissions, but I do think I need to say something, although I obviously can't cover all of them. But Madam, can I just can I run through some? Firstly, the suggestion that we had agreed a combined trial is wrong, as is the suggestion, and Madam, I quote, "At no point in time have they ever said that this is a case that they thought was appropriate as a split trial." And another quote, "We have merely alluded to that." Madam, that is a travesty of the true position. I have taken you to various iterations of our draft directions from February 2020 all the way through until May, which make clear in every single iteration that we anticipated that this was going to be a split trial on liability and injunctive relief. And I've taken you to correspondence both with the court and with KBH in relation to that. And the suggestion that this is all somehow our lookout and that we should have been proceeding on the basis since February that there was going to be a trial on all issues is frankly obviously wrong, not least because Ms. Ahmed just said to you that this issue only crystallised on the 14th of May. So she can't have it both ways to say, well, you can't criticise us for only putting in directions about expert evidence yesterday because this issue only crystallised on the 14th of May, but somehow say we should have been preparing for trial on all issues since February. In our submission, the suggestion that that's what we should have been doing or that's what we understood is simply wrong. Secondly, it was said that we only set out our position as to a split trial for the first time today. Again, that issue is wrong. We set out our position in our letter to the court on the 19th of May. Madam, I took you to that briefly, or at least I referred you to it briefly. I don't ask you to look at it now. It's a 3 or 4 page letter at page 231.
Yes, I recall, thank you.
And Madam, we addressed the matters for the first time this morning that were raised in the defendant's skeleton because they were raised in the defendant's skeleton. And so we have responded to them today, as you would expect in a litigation. Madam, thirdly, the suggestion that this is a shameful exercise, the phraseology used by Miss Ahmed, and that my clients are being vindictive, trying to delay and trying to punish Mr. Olayanju. That is frankly a deeply regrettable submission. Mr. Olayanju is the individual who is in breach of his contract. He, of course, has the choice to continue working for us if he wants to do so in accordance with his contract. He has chosen not to. If he was concerned about hardship, we could have been in a trial in this case in May with a judgment by now. And we note with interest the suggestion that he is paying for his legal fees. Doubtless that's a matter that we will deal with in part in cross-examination at this trial. Madam, fourthly, there's no ambiguity about quantum being dealt with at the same time in our submission. On the contrary, our particulars of claim, you will recall, where we referred to a claim that we would particularize in due course, came after we had already had the interim injunction application, after we had already set out in the directions, the draft directions for that there would be a split trial in the usual way. And as I say, we have proceeded on the basis that there was a split trial throughout. And it's not a question of hedging our bets, not least because whether to pursue a claim on damages is almost invariably tied up with what the result is on a liability judgment or an injunctive relief judgment. Because if an employer gets the full relief that they are seeking, very often there will be no need to seek quantum, or an employer will choose not to do so. Madam, the suggestion that there'd be two lots of costs in our submission doesn't stand scrutiny. There will be costs to be incurred on liability and injunctive relief. There will be costs to be incurred if there's to be a quantum trial, but the costs are separate and distinct, and that's because the issues are separate and distinct. And you heard Miss Ahmed say to you, well, there's an overlap on issues, but frankly, apart from her asserting that, she didn't explain what they were, and that's because in our submission, there aren't any. Madam, the point we made by reference to the English authorities was, as we made clear in our skeleton, not that you were bound by them, but we suggested that they might be helpful to have regard to, and we expressly made the point, and the reason why we took you to those authorities and the way in which the English courts split off liability and injunctive relief and quantum in cases such as these is because they reflect the overriding objective, and they reflect the fact that liability and injunctive relief on the one hand and issues of quantum on the other do not overlap. Madam, sixthly, in this jurisdiction, as to the way the DIFC courts approach these matters or cases of this nature, can I just remind you of the ED&F Mann and O'Brien case, which was before the courts a couple of years ago. Madam, you may recall that there was a split trial on issues of liability and injunctive relief in that case, which is perhaps the closest case there's been in the DIFC court to this trial. Madam, I don't accept that we are not in speedy trial territory. I again remind you of the original draft directions or case management sent out by the registry anticipating a trial in April 2021. And the suggestion that we have been progressing this case for 7 months in our submission doesn't withstand scrutiny for the submission I made for the reason I set out at the outset. We have not been progressing this case on quantum since February, and as Ms. Ahmed said, this issue only crystallised a few weeks ago, so neither party has progressed quantum. Madam, you asked if there had been a trial in May or in June, would Ms. Ahmed's submission have been the same, and she sought to suggest that it would have been, but Madam, in our submission that simply doesn't withstand scrutiny. The procedural timetable where we were at the end of April when we last came before the court, there were no directions for expert evidence. It's accepted now that there should be expert evidence in this case. There was no provision made and the position simply changed in mid-May, and the question therefore is whether you should drop quantum in now for a trial starting in 12.5 weeks. Madam, next, I did not say, or we did not say in our skeleton or our note for this hearing at paragraph 8.2, that judges of the DIFC courts are incompetent and that therefore we had made an embarrassing submission. That's not what we said at all. The only point we were making that the complexity of quantum in cases such as these, which frankly is a general and understood principle, is such that it would put more pressure on a judge who would be required to provide an expedited judgment, if at all possible, if he or she had to deal with issues of quantum as well as liability and injunctive relief. Madam, as for the suggestion that what the court would be concerned with in relation to a lost profits claim is his historical revenue and simply his performance in the desk, it is wrong. The question is, what damage have we suffered by reason of his breach? And the court then has to look at the but-for world, in other words, what would have happened between the period December 19 and April 2022, having regard to his trajectory, the trajectory of the desk, our position, the market and such like, and the actual world. And just in relation to the suggestion that's made about individual versus desk revenues, can I just quote something that was said by Mr. Justice Jack in the Tullet Prebon case on that? And I have to read it to you because I didn't anticipate this submission, so I've just, in fact, Ms. Rogers pulled it out. He said this: brokers are organised into desks in accordance with the products in which they deal. Desks vary in size according to the amount of business which the company has on the product in question. A large desk has a very substantial advantage over a small one because of its greater liquidity. Put in simple terms, that refers to the greater ease which a broker has in finding a buyer when he is instructed, for example, to sell $10 million 1 month forward. If he has 10 others on his desk, he may be receiving offers to buy dollars forward. The brokers on a well-run desk work as a team to secure business. By working as a team, a desk increases its liquidity and the chances of putting together a deal between traders. The two brokers involved will then each earn brokerage for their company. So the idea that you simply look at one individual in our submission doesn't stand scrutiny, and indeed is contrary to authority as to how a court should approach losses in this case. Madam, I've no idea what Ms. Ahmed might have said to an expert that would have caused that expert to say this is all very simple and can be dealt with in a couple of weeks. But that is certainly not the experience of the legal team, or certainly not my experience in dealing with cases of this nature, that these issues are straightforward. On the contrary, they're not, which is why the cases say just that. Madam, I didn't suggest that there should be different judges dealing with liability and quantum. The submission I made was, number one, in principle, that may not be problematic. It often happens. But equally, there's no reason why one judge shouldn't hear with both matters. The overarching question is always what is in accordance with the overriding objective. Madam, the suggestion that this is somehow not a complex case or that there aren't going to be a substantial number of documents, can I just remind you, we set out in our case management information sheet that on liability and injunctive relief alone, we anticipate disclosing 4,500 pages worth of documents. So that, apart from anything else, will doubtless explain the cost. And if Mr. Olayanju and GMG had spent 100,000 dirhams, we hope that that does not reflect they have not done a proper exercise. Madam, on the questions you put to Ms. Ahmed about the claim that the defendants bring, it's absolutely plain in our submission that the loss that is claimed, including the triple damages claim, is all occasioned by the injunction and will depend on whether we are liable under the cross undertaking. And the assessment of any of his loss is under the cross undertaking. That is not a trial on quantum. That is simply a determination of whether or not the claimant should be liable to compensate the defendants under the cross undertaking that they have given. And in the usual way, the court will have to assess liability. If the court were to be against the claimants on their claim and say that we should never have been granted the injunctive relief in the first place, then the court, in the usual way, would deal with any question on a cross undertaking on damages and whether or not we should be required to pay. Now, Madam, we have no difficulty at all with listing a further hearing if that is what the court has in mind, provisionally on a cross undertaking. Frankly, that would ordinarily come on soon after a liability trial in the event that the claimants failed in getting final injunctive relief. And if it's convenient to the court and the court wants to list another hearing simply on a provisional basis in relation to our cross undertaking in damages, for example, later in September, we have no difficulty with that. But the issue that we are here disputing isn't about a claim under the cross undertaking in damages. What we're talking about here is a claimant's claim for quantum in relation to lost profits and or negotiating damages. And Madam, again, we haven't put before you the authorities on the complexity of dealing with negotiating damages, but from the one-step trial here, the courts have made clear that those issues or dealing with those questions have become, to use the phraseology of the court, increasingly elaborate, and a host of questions often emerge as the basis on which they should be hypothesized. So they are also complex claims. So as I say, we have no difficulty if you have in mind provisionally putting in some date now for a determination on the cross undertaking, if it were ever to become a live issue, with that. Madam, the overriding objective, which Ms. Ahmed constantly refers to, Madam, can I just remind you, one of the central features of that is saving expense. And as I've said, it may be that quantum would never be a live issue in this case, either because we don't pursue it, or because it's settled, or because we lose. And also dealing with cases in a way which are proportionate to the issue. And Madam, in our submission, it's absolutely plain that the proportionate way of dealing with this matter is in the way that we have suggested by way of a split trial. Madam, unless there are any other particular points that I haven't addressed, I obviously can't deal with all the matters that Ms. Ahmed dealt with. But,
thank you, Mr. Craig. That was helpful. Thank you. My proposition is this, or rather, I've certainly made up my mind. First of all, thank you, Mr. Craig. I do think that the courts of England and Wales provide sensible guidance in the context of how liability, injunctive relief and quantum should be dealt with. In this case, having heard both sides, I'm not convinced that liability and quantum are sufficiently connected or mingled to the extent that they should be dealt with jointly at the same trial. At the same time, I don't see any reason why the defendant can't make a claim under the cross undertaking either at the liability trial or soon thereafter. So I suppose my direction in that regard is that the defendant will have some time and we can issue case management directions closer to the time on whether, or perhaps at the liability trial, on how much time the defendant has to bring a claim under the cross undertaking in the event that they wish to pursue that sort of claim. I have taken into account the time, cost and prejudice submissions raised by Ms. Ahmed. And I feel that in balancing the prejudice, I think that it would be more prejudicial for me to order that the quantum trial proceed at the same time as the liability trial and injunctive relief trial, because that might not give the claimant the relevant time and opportunity to assess the heads of damage that they wish to claim. I don't think that these have been sufficiently set out in the particulars of claim. It's quite clear that paragraph or part 7, paragraph 40 of the particulars is very brief. It says that these are the types of heads of losses that we anticipate in claiming, but this is not an exhaustive list. I don't think that the claimant could use that particulars and run with it at trial. I think the claimant would be required to apply or at least seek permission to amend their claim form and particulars of claim. And I think to now, at this very, very late stage, to grant the claimant permission to amend the claim form in order to set out in detail what the different heads of damage are, and also to then amend the particulars of claim, would mean that then the defendant would have to go through the same exercise. So you've gone back to the same question of costs will increase no matter what. I agree that, and I'm convinced that the claimant may not pursue the damages claim down the track. I don't want to speculate the different or the types of loss which could be claimed by the claimant in the event that the trial was to go ahead on quantum. But I do believe that they do need time, and they're entitled to time to investigate what types of losses may have been suffered, and in any case, whether it's worth going ahead with a quantum trial based on the amount of loss that they might have sustained. And they won't know that amount or those amounts until they engage experts, which would take some time. So I don't want to throw the current schedule off by changing what we've already got in mind. I am convinced that from the outset, the claimant had only intended to deal with liability. I did make a comment when Ms. Ahmed was making her submissions that it was slightly wishy-washy, and I think that was deliberately so done by the claimant strategically. So I don't want to derail the smoothness, if I might say, of how the current liability and injunctive relief case is being planned. I think let's proceed with liability only. That will be dealt with at the trial on the dates agreed by the parties, which I think those dates were the 1st to the 5th of September. So I will make those directions. It may be the case that shortly after the liability trial, we issue further case management directions on the application of either side on when quantum is to be dealt with and the directions in respect of quantum. It might also be the case that I issue directions after the liability trial in the event that the judge doesn't do so himself or herself to suggest that a new claim form is to be filed. And that is to ensure that the cases are split neatly. We'll deal with that shortly, very, very shortly after the liability trial, if not on the trial date, or otherwise hopefully a week or two after that date. But I think that has concluded all of the issues. I don't propose to make any orders in respect of costs. I think costs should be in the case unless the parties wish to make submissions in that regard.
Madam, can I just pick up a few points in relation to that? That's very helpful. Thank you very much. Firstly, you referred to a trial on liability. I assume you meant liability and injunctive relief.
Of course, and I always, just for the avoidance of doubt, I have been saying trial on liability, but at all times I did mean the trial on liability and injunctive relief. It's just a bit of a mouthful to pronounce. Correct, thank you.
Understood, thank you. As for the date of trial, I think the parties had agreed, subject to the court's approval, the 6th to the 10th of September, not the 1st to the 5th. 2 points. Number one, can the court accommodate those dates? Number two, I'd be interested to hear what the defendant's position is as to trial length, given what appeared to be the submission that 5 days would be sufficient for all issues of liability, injunctive relief, and quantum.
Yes, Ms. Ahmed? Ms. Ahmed, are you on the line?
Yes, sorry, I forgot to unmute myself. No, my suggestion was that perhaps we allow Mr. Craig to finish all of his points, and I can address those together.
Okay, thank you.
Madam, then just on directions, I wonder whether you have our note, because at paragraph 11, we set out a table of the competing directions.
Yes, I do, thank you.
So the first issue is about when principal witness statements should be exchanged. The defendants say that should be the 6th of August. We had originally proposed the 9th of July. I say originally, that was by reference to the defendants' directions for a trial. You'll recall they were seeking a trial in August. We just put back the dates because the trial was going back to September. So, Madam, we are prepared to compromise on that, but, Madam, we don't want to go beyond the 27th of July, and the reasons for that are that you will recall a number of our witnesses are away in August, so we very much want to have principal witness statements exchanged before people go away, so that we can get instructions from them in late July for the purpose of putting together the reply statements. If they come on the 6th of August, that makes it much more difficult for us. There's a dispute between the parties as to whether it should be the 27th of July or the 6th of August, and I've explained our reasons as to why it should be late July. Madam, we're prepared to push back date for reply statements by a month, the 24th of August. We've set that out again in the table. Madam, next is the trial bundle index. We had originally proposed the 6th of August. The defendants wanted the 24th of August. Madam, we think that's too late. We want at least 3 weeks with the trial bundle before trial, which means agreeing a trial bundle index and our submission no later than the 13th of August. Once the index is agreed, obviously the bundle can be put together, but assuming that that's going to take a few days, then it can't be any later than the 13th of August. If a trial bundle index isn't agreed until the 24th of August, we're not going to end up with a bundle until really very, very close to the trial. Madam, I also raised this issue. We are slightly concerned in any event about dates being pushed back too far because of the risk that deadlines will not be met. Madam, I don't criticise the defendants in relation to this, but you will recall that we served, for example, our request for further information on the 7th of April, and we didn't get a response until the 18th of May. So it took them an awfully long time to deal with matters, and that, of course, was a week after the generous additional time that the court had given. So, frankly, we just don't want to have dates coming as late as the 24th of August in relation to trial bundle index. For all the reasons that I've set out. So, Madam, they're the areas of dispute. When should principal witness statements be served, and when should the trial bundle index be agreed?
Okay, thank you very much. I think the timetable proposed at paragraph 11 is sensible.
Madam, can I?
do recall.
Sorry, Madam, can I?
Yes.
Can I give you my representation?
Of course.
Yeah. Thank you, Madam. Firstly, thank you very much for your judgment. If I could just perhaps raise one point in relation to your decision. I won't ask for a formal written decision, but what I will request and invite you to consider is whether or not the points that have been made can be perhaps put in a recital. So, for instance, a new claim form filed in relation to quantum, because you think that that will neatly split the claims. I think it would be helpful to have those comments memorialised, and therefore we would invite Madam Registrar, Deputy Registrar, to put those in writing at some point, perhaps in the order or in the recital of the order. But I think that will be helpful in terms of going forward. In terms of the dates that have been agreed for trial, that's the 6th to the 10th of September. In relation to the trial length, my learned friend has asked for my observations. You'll recall in my submissions I did say that even if 5 days isn't sufficient, because the court will deal with quantum, then there's no reason why we couldn't extend the duration of the trial. But in any event, this, 5 days is appropriate. I don't think it's going to take that long, but clearly the claimants do, and therefore I don't think there's any issue of dispute there. And so we're happy to keep the 5 days unless the claimants agree to a shorter time duration for the trial. In terms of the directions that have been proposed, Madam, can I take you to my draft CMC order and provide an explanation of those dates? In terms of the disclosure exercise, the 11th of June, that's agreed. Let's just turn to the witness statements. Originally, it was agreed that witness statements would be exchanged on the 27th of July. That was on the proviso that the court would list the trial in August. However, the court hasn't listed the trial in August, and therefore there is availability of, and room for flexibility there. And in that context, Madam Deputy Registrar, what's good for the goose is good for the gander. If the claimants are entitled to have time in relation to putting together their claim for loss, then equally we say that the defendants ought to have an adequate opportunity to have sufficient time in which they can compile and serve and draft their witness statements. And taking into account sort of the commitments, the claimants are aware that I am due to give birth on the 30th of June, so at the end of this month, and therefore we would, for the defendants, allow some extra time in which those witness statements can be drafted and served, and therefore we say that the appropriate time would be the 6th of August 2020, taking into account my commitment. Also, we say, and this and reference was made to this point in our skeleton argument, that in light of the COVID-19 situation, again, we still don't know how that's going to play out. There's been no opportunity to meet my clients face-to-face. Everything has been done remotely, and therefore, taking that into account, and by good authority from the UK courts, and I think it's the case of Jallo, which has been referred to in my written submission, time should be factored in to take into account the difficulties that remote working pose, and therefore, on that basis, 6th of August 2020 has been proposed. My learned friend has said that poses some difficulty in relation to his witnesses. Again, it's interesting to see that there is no real submission being made as to what their witness availability is. However, during my call with Rebecca Copley, the partner, that was on the 14th of May, we discussed witness availability. And at that time, it was proposed that there would be 4 witnesses. In relation to the witnesses, the information that Ms. Copley gave to me was that the first witness wasn't available between the 3rd to the 16th. The second witness wasn't available between the 7th and the 23rd. And then the third witness was only available after the 10th of August. And then we didn't know what the fourth witness was. Now, clearly, that position has changed because there are more witnesses, but we don't have any transparency or visibility as to what their availability is. It's unlikely that all of these witnesses are going to be away at the same time. And in any event, there's no reason why witness statements can't be worked around their witnesses' availability. If the claimants are saying that they can file and serve witness statements by the 27th of July, then there's no reason why they can't do that now, or rather prepare for that filing on the 27th of July. However, it would be of great assistance to the defendants if we were allowed the date of the 6th of August to be able to exchange witness statements of fact, given the difficulties that I've explained to you. That's the reason why the 6th of August is proposed. In terms of reply witness statements, the reason why the 24th of August was agreed to allow the claimants' witnesses extra time because of their availability issues. We provided for 3 weeks. The usual time is 2 weeks. But again, that was a compromise on our part because, of course, the claimants were saying about witness availability. And therefore, the 12th of August, we say, is a workable timetable, despite the claimant's witnesses availability. And then in terms of the trial bundle, the claimants are proposing the 6th of August. What we would say is that we are prepared to compromise on the 6th of August date, but what we would say is that if an index is agreed, then we should be able to have access to the trial bundle at least 3 weeks before trial as well. That's the only caveat that we would put there.
Excellent. Thank you, Ms. Ahmed. First of all, congratulations on your pending birth. I was going to say that I agree with the directions in paragraph 11 proposed by Mr. Craig, except for the 6th, because I think that Mr. Craig could probably get his witness statements in before that date, and then it would mean that he's got a slightly shorter window to then read through the witness statements provided by the defendants and then generate a reply to those witness statements. But I think the 6th of August could be managed, Mr. Craig. So why don't we stick with 6th of August for the witness statement, 24th of August for the reply statement, and then the trial is tentatively listed on the 6th of August for a period of, I know you said 2 to 3 days, Ms. Ahmed, is that correct?
Sorry, the listing of the trial?
Yes.
The 6th of September,
Sorry, 6th of September, but, sorry, beg your pardon. 6th of September, but did you say 2 to 3 days is sufficient?
No,
considering
I said that 5 days. 5 days is quite long, but the claimants have proposed 5 days as well, and so there's no reason why that 5 days shouldn't be set aside for this trial. Okay,
so we'll stick to 5 days. It looks like we do have judges available on those days, so we can tentatively list it for the 6th of September to the 10th of September, and if we've got any, sorry, to the 11th of September rather, and if we've got any problems with the listing, then we can revert to the parties. I don't anticipate that we would list it much later than the 6th of September if we've got any issues with the listing. So we'll stick to that date for now. And then very finally, exchange of skeletons and bundles. I would like that exchange 5 working days before the trial, please, or 5 days is sufficient. So if we aim for a date of the 1st, Tuesday the 1st of September, for the exchange of skeletons and e-bundles, please.
Yes. Madam, I'm sorry.
Yes, Mr. Craig.
Sorry, just you said the 6th to the 11th. I think it is 5 days will be the 6th to the 10th, inclusive.
I apologise. I'm not very good with numbers, and you're correct.
No.
6 to the 10th.
I just want to make sure.
You're correct.
Make sure that we're all
yes,
talking.
You're right.
About, yeah, that's
absolutely
fine.
6 to the 10th.
Yeah, I'm grateful. Thank you. And then, sorry, the point that Ms. Ahmed made about recitals to your order, I wasn't entirely sure what she had in mind. My understanding of your ruling, your judgment, was that there would be further directions made after the liability trial, either at the end of the liability trial by the judge at the end of that trial, or directions made thereafter by you. If I've misunderstood that, then it would be helpful just to understand that I have misunderstood it.
This is correct. I was mentioning as well, or I did mention that it might be prudent at the time the directions are made that a new claim be filed, which deals with quantum. One thing I want to deal with, which might be worth dealing with now, is whether the claim form ought to be amended, in which case then you'd have to file a brand new claim dealing with quantum. I know that probably is not the claimant's preference, but whether the claim form ought to be amended to deal only with liability and injunctive relief, so that there's no confusion. What are your thoughts, Mr. Craig?
Speaking for myself, I don't think that's necessary because I mean, the court has effectively held that there should be a split trial, that the court should deal with issues of liability and injunctive relief. That doesn't mean that there isn't an extant claim in relation to quantum. It just means that what will happen with that claim on quantum will await the result of the liability and injunctive trial, or at least await a judge's views at the end of that trial as to what should be done in relation to quantum. So I mean, ordinarily one would have one claim form dealing with all issues, liability, injunctive relief, quantum, whatever it may be. If the court then decides that it's going to split the issues in whatever way, I mean, sometimes it would be taking a different preliminary issue. It doesn't necessarily have to be the whole of liability. It could just be one issue on liability that it would deal with as a preliminary issue. That wouldn't mean that you need to issue a claim form with a balance. So in my submission, the claim form is fine, and the court is simply case managing this claim form in a way that it considers most sensible.
Okay. Ms. Ahmed, what I would propose is, because the comments that I made, I suppose, form part of my obiter comments, and they're not part of my ratio or part of my substantive order or judgment. So you could request a transcript of the hearing, and a recording of the hearing will be available, so you can rely on the comments that I've made. But I don't think that it's necessary for me to include those comments in any recital section. I don't think it would make sense to include it in the CMC order. But you can always obviously rely on what was discussed on the record by referring to the transcript of the hearing today.
Indeed. Thanks, Madam.
Thank you, Mr. Craig and Ms. Ahmed and everyone else. Is there anything else that remains outstanding that we have to discuss?
I think, Madam, I don't think we settled on a date for the trial bundle, did we?
The trial, yes, we did. So the trial bundle will be filed with the skeleton on the same day, being the 1st of September.
Well, Madam, I think then we need to sort of discuss when the trial index ought to be agreed, because if the claimants are saying that the trial index ought to be agreed 3 weeks before trial, then it puts the defendants at a disadvantage that they have an agreed trial index and they're probably going to get on with preparing the trial bundle, and claimants have the trial bundle, but yet it's only provided to the defendants 5 clear days before. And obviously that will also have an impact in terms of the referencing of any opening statements or skeleton arguments. So I think we just need to clarify what the directions will be for provision of trial bundles.
Okay. So what do you propose, Ms. Ahmed?
Well, I think my learned friends, the claimants, is saying that the trial bundle index ought to be agreed on the 6th of August. I mean,
I'm sorry to cut across you. We compromised at the 13th of August. We had originally proposed the 6th. The defendant said the 24th. We have said we're prepared to put it back to the 13th, but no later.
13th of August. So that's agreeing the trial bundle index on the 13th of August. And can I just check, when do they propose to send the trial bundle to the defendants? Because 5 clear days beforehand was obviously quite late.
No, we wouldn't be proposing that. We'd send a copy of the trial bundle to the defendant when it's ready. So that will be as soon as possible after the 13th of August.
Sorry, you cut out, Mr. Craig. Sorry, you'd be proposing to send...
once it's ready. We'd send it
And how long do you think?
well, it will take a few days, I'm sure, but you know, you will get the bundle when we get the bundle. There's no suggestion that we would not provide the bundle to the defendants before we provided it to the court. As I understood it, Madam, your order was simply about when the court should receive a bundle and the skeleton arguments. Doubtless the court will want the bundle for a judge to be able to do some pre-reading. But as between the parties, yes. The parties will get on with dealing with the bundle between themselves. So we'll agree a trial bundle index on the 13th of August, and then we will put together the bundle thereafter. I can't tell you whether that's going to be 2 days, 3 days, 4 days, or 5 days. But I mean, I don't know. It will take as long as it takes, and once it's done, we'll provide a copy to the defendants in the usual way.
Just to latch onto that, Mr. Craig, Ms. Ahmed, in my understanding, that's because the both sides or all parties would have access to all the documents that would be included in the bundle by that stage. So long as you've got the index, you can then navigate the documents on your systems. It's just that obviously it's much nicer to have a clean single bundle that you can work off. But are you happy with the date of 13th of August?
Absolutely. So index to be agreed by, absolutely. The index to be agreed by the 13th of August, and perhaps we could put in provision that the bundle is provided no later than 5 days from the date of the 13th.
Okay. Now,
Great.
Mr. Craig, could I ask your team, please, to prepare a case management order setting out the directions that we've discussed today, a copy to be sent to Ms. Ahmed and her firm, and then the agreed draft to be circulated to the registry?
Yes, of course.
Thank you very much.
Thank you very much, Madam.
Thank you so much, Mr. Craig, Ms. Ahmed. I expect that now resolves all of the issues that were pending.
It does, Madam. Thank you.
Yeah. Thank you very much. Have a lovely day. Thank you. Bye-bye.
Thank you. Bye-bye.